In respect of items 36 and 37, these two matters relate to the delimitation exercise in the TUA Autonomous Council. In order to redress their grievance, a committee was formed which included one of the then ministers. So now in the present circumstances, we will be requiring some more time, possibly some other person will have to come.
In 37, I am for the petitioner. They've informed us.
37.
In 37.
36 and 37 both are same.
Analogous matters.
Analogous matters.
How much time you need?
Lordship will give us 4 weeks time, my lord, because
Yes, Mr. Borua.
Well, only let them fix it, finish on 18 June. Man.
Mr. B. Majumdar, Learned Additional Advocate General, Sam, has submitted that you need order 4 weeks time to apprise the court about the process of what is the subject matter?
Delimitation. Man.
delimitation.
Process of delimitation in respect of the TUA Autonomous
My
Council.
lord.
Yes, therefore, short listing of the cases. After 4 weeks, Mr. A.K. Borua, Learned Counsel for the petitioner in 37, who is present, has agreed to the prayer made by the Learned Additional Advocate Assam. Sought for and agreed to by the Learned Counsel for the parties list the cases on the after 4 weeks. And I did
19.
Public.
Lordship, with the consent of the other side, I beg to mention item number 49, Lordship. Lordship, the matter may be taken up on a hearing date. If convenient to my lord, may I propose 2nd of June?
Okay, let us see what is the matter. They have to decide. Be there.
My pleasure. I beg to mention item number 4 on behalf of Mr. Goswami, UK Goswami.
Item number 4.
4 may be taken up on Wednesday. madam.
What is the subject matter?
In fact, I'm not there in this case. It's relating to
Friday?
Friday.
Okay, on the prayer of the Learned Counsel for the petitioner, release the case on Friday. You have informed the other side.
Yes, please.
Mr. H. Bura, what is the subject matter?
Lordship, here regarding the change of the registered mobile number of the account holder.
Okay. H. Bura, Learned Counsel for the respondent 1 and 2 is present.
Okay.
Friday?
Small prayer, Lordship. On 15th, I'm having some difficulty, Lordship. Any other day, Lordship.
Okay, then Wednesday.
Wednesday.
Okay.
13th.
May I please, Your Lordship? Lordship, I beg to mention item number 6, Your Lordship.
Yes.
I'm praying for Mr. Ganguly, Your Lordship. When I will listed after a week, yes, some personally difficult to me. It was last listed on 5/5, Your Lordship. Came on today.
On the prayer of the Learned Counsel for the petitioner, place the case on next Monday, Monday. Mr. J. Henrik, Learned State Counsel for the Learned Junior Government Advocate for the state respondents is present.
Wonderful.
May it please, my lord. My lord, we have filed an affidavit in opposition in a contempt case that has been listed today, item number 43, on behalf of respondent number 1. I would like to bring that on record, my lord.
Okay.
May it please, Your Lordship. Kindly list one contempt matter on tomorrow, Lordship, for orders. It may be not placed on tomorrow, Lordship.
Not placed. Okay.
May I please, I beg to mention for listing, my lord, on admission matter, my lord. Matter relates to compensation of
Get
land.
it in the withdrawal column then.
My lord, matter relates to land compensation, my lord.
Admission.
Yes, my lord.
Okay, give it to the court master.
May it please, Your Lordship. I beg to mention item 12 of today's list, Your Lordship.
Yes.
I may be allowed to withdraw with Your Lordship with liberty to file afresh.
Ms. Saif Hussain, Learned Counsel for the petitioners, has submitted on the instructions on instruction that the petitioners want to withdraw the writ petition with a liberty to file afresh. Mr. J. Henry, Learned Junior Government Advocate for the state respondent is present in view of the above submission made by so and so. The writ petition is dismissed on withdrawal with the liberty as prayed for.
Oblige, your lordship.
My lordship, but I have to mention item number 48, my lord.
48.
So I have some difficulties today, my lord. I need your lordship only for accommodation today, my lord.
Oh, it has come for what?
Orders, my lord.
Huh?
Orders, my lord.
For service or what?
For service, my lord.
We'll see.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 2, Lordship. Kindly the
Yes.
matter may be taken up next week, Lordship.
Okay, on the prayer of Mr. A.K. Sahal and S.K. Sahal and Council for the petition, and leave the case on next Monday.
18.
Oblige, Your Lordship.
Okay, you have informed the other side.
Yes, Your Lordship.
Likhiju.
With the consent of the other side, Lordship, I beg to mention item number 29. In this matter, Lordship, we were directed to file an additional affidavit that has been sent for vetting, but the concerned officials are on leave, so the matter may be taken up after 3 weeks.
You are for respondent?
Respondent
Respondent
number
number?
1, 2, and 3,
Okay, Miss
as they.
as the Learned Counsel, on behalf of the respondent number 1, 2, and 3, has submitted that the additional affidavit has been sent for vetting, and the same would be filed within what time?
3 weeks, Lordship.
Within
Under
3
the-
weeks?
2 weeks, my lord.
Okay, 2 weeks time. So he has just sought for listing of the case after 2 weeks with the consent of the with the consent of Mr. A. Bhattacharya,
On behalf of
Learned
the
Counsel, on behalf of Mr. D.J. Kapil, Learned Counsel for the petitioner, who is present, who is in attendance. Leaves the case on so and so.
3rd June, 36.
May I please, Your Lordship, I beg to mention for listing, Your Lordship, the matter relate to default of the AMI of a commercial vehicle. Your Lordship. Matter to relating to the default of AMI of a commercial vehicle, Your Lordship.
EMI,
Yes, civil.
ठीक है sir. The motion.
No, your admission hearing, Lordship.
Okay, give it to the court master.
May I please, Your Lordship? Lord, I beg to mention item number 20, my lord. I'm on behalf of Jiuddin, my lord. Due to some his immediate family difficulties, my lord, he is not available in the
Mr.
court.
Counsel, you are without band. Please come before the court properly dressed.
May I please, lordship? My lord, I beg to mention item number 46, my lord, in order column, my lord. I am appearing on behalf of respondent number 8, my lord. My lord, I need 4 weeks time to file affidavit, my lord. So, my lord,
Let us wait. This is for service report.
yes, my lord. No, service complete.
Just see and pass the order.
Obligation, my lord.
Please, Your Lordship. Your Lordship, I'm appearing for item number 14 for motion category.
Yes.
Your Lordship, may,
Okay, leave the case before any other events without me.
Your Lordship may kindly fix the
That I
matter.
cannot fix.
May I please, Your Lordship?
Item 40 is
Item number 38 is a contempt matter, my lord. Last occasion, my lord, directed to complete the process of a compensation. Accordingly, that has been completed, my lord, and that amount has been, my lord, deposited to the, my lord, Deputy Commissioner Kabru. And within 2 or 3 days, that will be released. And immunity bond from the petitioner has been collected by the DC.
So you are posting after 1 week.
No, Lordship, my lord, maybe closed, my lord, but because
That-
amount will be get, my lord. I informed the Sabasasi Choduri, petitioner council.
Let him come.
No,
Mr. Bhagavati, you are for petitioner.
no, he is for one.
Okay, let you comply with all procedure. Then we will post it on next Monday.
Uh, Monday.
Let us see. If that Mr. Chaudhary has agreed, then okay, no issue. We'll withdraw.
My lord, already, I think my lord, they will get it.
No, let us see, let us see. This is a contempt case. This is not in a manner. Mr. T.C. Shutia, Learned Counsel for the Learned Senior Counsel,
Yes, my lord.
paying for the respondent number 3, have start listing of the case on after a week. In order to apprise the court regarding compliance, regarding completion of all the requisite formalities to disburse the amount, stated to be agreed by the petitioner. Okay, list the case.
That may be kept on records, my lord. Monday, my lord.
Monday, the instruction, sorry, the letter, office letter, bearing number so-and-so dated 8/5/2026 of the GMDA, placed by Mr. Sutia, is to be kept with the case record.
May I please, Your Lordship?
Lordship, I beg to mention an item for withdrawal on tomorrow, Lordship.
Tomorrow, okay.
Obliged, Lordship.
Sorry, my lord. My lord, I beg to mention item number 20, my lord. I am on behalf of Jiuddin, my lord, due to some is family.
On behalf of?
Jiuddin, my lord.
Yes.
Due to some is family related difficulties, he is out of station, my lord, today, not available in the court.
Mr.
A.K. Azad.
A.K. Azad, Learned Counsel, appearing on behalf of Mr. G. Uddin, Learned Counsel for the petition, has submitted that Mr. Uddin is out of station due to personal reason. He has thus sought for listing of the case after a week. Post up. You have informed the other side.
No, my lord, actually, I have not
Okay, you
never.
wait for, let us switch. Don't have, because I have seen, faced many issues.
My lord.
Counsel starts complaining.
Daily list for motion, item 1.
May it please your lordship.
Yes.
Your lordship, a contempt application has been filed before this honorable court for
Which order?
for non-compliance of order dated 19/11/25, which was passed by this honorable court in
Miss.
WPC 3.
Miss.
Your lordship,
Your name, please. Good name.
DB Gauhati.
DB Gauhati, Learned Counsel for the petitioner. First up, this contempt petition is filed alleging non-compliance of the directions made in an order dated 19/11/2025. In a petition WPC number 3505/2025. Post up. One of the directions made in order dated 19/5/2025 to the respondent authorities to verify the entitlement of the petition on the basis of the work orders within a period of 1 month from the date of submission of a certified copy upon the respondent. Post up. It is averred that a copy of the order dated 19/11/2025 was served upon the respondent number 2 on 4/12/2025. Post up. Issue notice returnable on so and so. The petition shall take steps for service of notice upon the respondents by speed post within 2 working days from today.
Deeply obliged.
Item 3.
Yes, my lords. My lords, this is the civil disputes, my lord, with the sole private respondents. My lords, unfortunately, the police has an interfering in this case and forcefully it's taken one undertaking from the petitioners and their family members. My lords. Lords.
Schedule plot of land of origin.
There are 8 of my petition. Can you?
Who are the petitioner? Who is the petitioner? Single
George-
petitioner?
George Rahan.
Single petitioner.
Single petition.
Petitioner is mother and siblings. There is
Page number 10, para 8, kindly. Page number 10, para 8, kindly.
Are you a patadar?
Yes, I am also one of the Pattadar, my lord.
Huh?
Yes, my lord.
You have lodged a complaint before police commissioner.
Yes, my lords, we have.
Why don't you lodge a case before officer in charge?
My lords, with the people used to page number 10, para 8, my lords.
Page number
10, para 8. My petition.
para 8.
Para 8.
So on these facts, whether this writ petition is to be entertained,
My lords,
in view of the settled position of law, what is your next approach? What should be your next approach?
my lords, if the private,
If the commissioner of police has not entertained your complaint dated 18/3/2026, what is your next approach?
lords,
What does the law says?
no, if whether my lords.
Law says that you have to approach the jurisdictional magistrate.
The magistrates will not entertain in this case, my lords.
Why?
Against police, my lords.
Why? Who says?
No, there should be.
Is it your submission?
It is my lord sanctions is required, you honors. To filing any complaint against the police.
It is, if it is, what is the present provision of registering an FIR?
There is sanction is required.
173 BNSS.
My lords, yeah.
Not registering an FIR of a cognizable offense.
No.
Is it?
My lords, the police has forcefully taken the undertaking from us. And they are directing. We have no grievance against my lords, in this case against the sole respondent. The police himself now involving in this case, my lords. And therefore we have approached before your lordship. Police cannot direct act towards vacate the plots of lands.
Where your
this is undertaking
where your complaint to the
my lords,
commissioner of police?
My lords, to be pleased to page number 36, my lords. This is the undertaking, my lords. The police has forcefully taken from us in police stations, my lords. Page number 36.
That we don't know.
And 40 lords. And the 40, this is the
Mr. Henry, take your instruction. What action has been taken on this page 40?
Lodge.
By the police commissioner? Otherwise, he has to approach
No,
the
approach to the
jurisdiction.
civil proceeding.
Give your instruction.
Lodge.
Heard Mr. Y. Sigdal and counsel for the petition. First up. and Mr. J. Hendrik, Junior Government Advocate for the respondent number.
Respondent number Lordship 1327.
1327, and Mr. A. Aforesaid, Learned, Standing Counsel, Revenue Department for the respondent number 2. One of the grievances raised by the petition in this petition is that the respondent number 7 had allegedly obtained an undertaking from the petitioner under coercion and regarding the said act of the respondent number 7, the petitioner submitted a complaint before the
Respondent number 5.
respondent number 5,
No, Lordship, respondent number 4.
respondent number 4, which was the receipt of which was acknowledged on 18th 2026. Post, however, no action appears to have been taken by the respondent number 4 on the basis of the complaint dated 18th 2026. Post of para. Mr. Hendrik, lo, in the presence, facts, and circumstances projected in this writ petition, do not this court is of the view that in view of the projected facts and circumstances of the case, a writ petition or the petitioner without approaching the jurisdictional magistrate has approached this court without approaching the jurisdictional magistrate under section 175 BNSS, read with section 173 BNSS, comma, full stop, and therefore the writ petition, the entitlement of the writ petition is in question. Full stop, be that as it may, Mr. Hendrik, Learned Counsel, Junior Government Advocate Assam, shall obtain instruction whether any action has been taken on the basis of the complaint filed by the petitioner before the respondent number 4 on 18/3/2026. Post stop. List the quiz on next Monday in order to enable Mr. Hendrik to obtain instruction in the matter.
1805. Item number 5.
Yes, I have forgotten. No, I have heard, I have forgotten. I have not.
I'll recapitulate.
Yes.
The petitioner, my lord, was the owner of a garden, my lord. They entered into an MOU with the private respondent number 6, my lord. Now, in terms of the MOU, they were supposed to apply for permission before the concerned authorities to facilitate the transfer of the garden and the bearer plants and a few fixed assets, my lord. Now, my lord, at page 73, lordship will find a permission was accorded with a few conditions that were stipulated on the following page at page 70.
In November, depends on second right to the mental government of Assam obligation for registration of agreement of sale in the power of attorney between lands and communities in certain conditions. APJ T Limited is the seller,
Yes.
proposed seller.
Proposal. Page 74, your lordship finds the conditions.
Yes.
Yeah, my lord has seen condition 1 and 4, which is the timeline. The agreement in the power of attorney will have a validity of 1 year. And within 1 year, that final conveyance deed has to be executed. Now, my lord, we incorporated these conditions specifically in the agreement for sale. And the agreement for sale was is annexed at page 77. And page 89, we made it clear that this agreement shall remain valid for 1 year, and the deed of conveyance shall also be done within that particular year.
Page?
Page 89, your lordship finds a reflection of those conditions in the agreement.
Yes.
Now, on the strength of this agreement, they took over the garden, started running it, but they did not conclude the sale within that stipulated 1 year. So eventually in 2025, when almost 2 years were over, we filed a suit. We filed a suit alleging that they are in breach of contract. They ought to have paid the balance money, concluded the sale. They've done nothing, but they have gone on with running the garden. Besides that, there were other allegations regarding non-payment of statutory.
Where is your suit?
Page 163.
Where is your prayer?
Prayer is at page 184.
Yes.
Prayer C, your lordship finds that prayer for release of the balance consideration. Like I said, there were other issues concerning reduction in zonal value, etc., which we said we are entitled. And also there were allegations of encroachment for which prayer F was incorporated.
Yes.
Now, in an appeal, in an
So
FAO,
basically it is for specific performance of the
Yes. We said
MOU.
basically you to the agreement for sale and both the MOU and the agreement for sale, because as per the agreement he is required to pay me balance, etc. And then the final conveyance deed has to be executed, which was also the mandate of the permission granted by the state. Now, in the course of the proceedings of that particular suit, my lord, arising out of an injunction application, my lord, an FAO was filed before this court, which your lordship finds at page 248.
What was the that application, Mizze case? Mizze case is for what purpose?
The injunction, my lord, not to sell, because we had
Not
made
to?
further sell it out, and
That is related to prayer F.
that is related to prayer.
Yes.
228 is the prayer in the miss case, my lord.
When it is not transferred to the other
Yes.
side,
Yes. My lord,
how
that-
it is transferred and alienation would come?
But-
Maybe parting with the position may
Yes, yes.
is there, but these prayers are
that
redundant.
time-
And the agreement for sale is not yet
Correct.
affected.
Yes, my lord.
Then sale deed is not yet affected. How can it be
Yes.
transferring and alienating? The concept is
Yes. But eventually, my lord, I'll show our apprehensions actually came true, my lord, because of the state action, which is why we are here. Now, my lord, page
no, but at the time,
at that time, yes, your lordship is correct, which is why injunction was declined also.
this is futuristic.
Yes, that's right. Page 248 is the High Court order, my lord.
So in the Miss case, notice was issued.
Notice was issued. Against that, they came in appeal. And in during the appeal, my lord, at page 250.
They are agreed by what?
Non-grant of injunction.
Who?
We filed the suit, we filed for an injunction. Injunction was declined, as in ad interim order was declined and merely notices were issued. That's why we came in appeal. And in the appeal.
On what basis? For transfer, stopping transfer and alienation.
For stopping transfer and alienation.
When the original transfer has not
Has
been
not
affected,
taken
how
place.
can it make a prayer for in a music case?
Perhaps at that point of time it was misconceived. No?
Then how can the FAO can be
So FAO was also
argued?
Argued, yes. FAO was argued.
How it is argued?
My lord, FAO.
But when transfer between the original two parties are not there.
Right.
Right.
No, my lord.
How can it be transferred or alienated to third party?
I'll explain, my lord. With the agreement, my lord, with the agreement which I had just shown in page 77, we were also required to execute a power of attorney. Now that power of attorney had vested all rights, including the power to transfer on my behalf to himself.
Power of attorney for execution of sale deed,
And
right?
other-
Which had not happened due to non-grant of permission
Yes.
by the government, because condition says
1 year.
if we go back to page 74,
It
says that proprietor of the tea garden shall apply for seeking no objection, meaning that the power of attorney will apply.
on my behalf.
No objection of government through deputy commissioner for transfer of the tea garden to the second party, that is the other one, Khobong,
Yes.
of the agreement within 6 months from the date of registration of
The agreement for sale.
for sale.
Yes.
Then 4, suitable conveyance deed shall be registered within a validity period of 1 year.
Yes.
That has not been affected.
That was not affected until then, my lord. So what happened subsequently is
With the Mize case,
That time
when
it was first- yes, I'll go down
things
to
were
it,
not
go
in
down to it.
existence.
Yes.
How can this be done in a FAO?
That
What is
was
the
done-
FAO?
Against the declining of the ad interim order, my lord.
What order has been passed?
Order was passed for the trial court to take a decision, my lord. The order is relevant for one reason, my lord. At page 256, if your lordship sees. 256, para 23, they made a startling revelation to us. From further on perusal of the letter dated 9/12/2025, issued by the Deputy Commissioner Tinsukia and produced by the Learned Counsel for the respondents today before this court, it appears that the validity of the agreement for sale and power of attorney has been extended by the government until further approval of the government regarding the registration of conveyance deed in respect of Khobong Tea Estate Private Limited. Hence, the only apprehension shown by the present appellant in the injunction and petition praying for grant of ex parte interim injunction does not appear to have any basis. Now, this we were not aware of until it was produced in the FAO. Now, this we procured subsequently, and this is one of the impugned orders, my lord, at page 258, annexure L. So our apprehensions eventually came true, my lord.
This validity of 1 year
Yes,
was creation of the government
correct,
wholly.
correct.
Otherwise,
Yes,
two private parties
yes,
Yes. may decide themselves.
Yes.
But since it is a tea land,
Yes.
government has some say. Now, initially they said, okay, validity period of the agreement for sale and power of attorney would be valid for 1 year. Then they extended for another 6 months. Then by this impugned order, they extended for another 6 months.
until all.
Right.
Yes.
Otherwise, a terms and conditions of agreement is exclusively between the two private parties. Government
Yes.
would not have any say how this term and condition.
Yes. Yes.
So this validity period is a thing which is imposed by the government.
So they can extend.
Right. Now, how you are agreed by it?
My lord, to answer that, my lord, that's very pertinent. Perhaps what your lordship is saying is since since we did not plan this 1 year timeline, it was imposed by the government rather. So government can anyways do it, my lord. Now, my lord,
No, I'm not saying that, but it is a thing.
that could be a
It is a
possible
thing
thing.
made by the government
Yes. Now, my
and
lord,
imposed by the government.
yes. Now, my lord, the permission was for execution of the agreement for sale. Now, that permission we had applied, but because unlike other land, perhaps for agreement for sale also you need a permission in the case of tea land by way of that OM. my lord. Now, if your lordship sees the MOU, which was initially entered between the parties, that also had an obligation or a
No,
stipulation.
after this MOU,
Yes.
you mean to say this 77?
MOU also cast a stipulation for an agreement for sale to be entered, my lord.
No, MOU, after that MOU, there is an agreement for sale.
Yes.
Right.
Yeah.
MOU has no binding value. That on a future that we'd agree to enter into an agreement
For sale.
and thereafter followed by a contract.
Yeah. Yeah.
Right.
Yeah. Yeah.
So after the MOU, this agreement for sale,
Yes. Yes.
you have agreed.
Yes.
And some terms and conditions are to be were allowed to be incorporated, were directed to be incorporated by the government for the very fact that it is tea land.
Yes. Yes.
Initially, how these tea lands have tea periodic pattas have come, it is basically a throwaway.
Yes.
That is why they have some control.
Yes.
Now, after that, this clause is agreed by 74 letter. After the 74 letter, you have incorporated those conditions.
Yes.
Right?
Yes.
Thereafter, it was extended again.
Yes.
And thereafter, by the impugn, this one, 9 December 2025,
Yes.
that has been extended again.
Yes.
Approval.
Yes.
Validity period is extended.
Yes.
And it is an application for extension on the basis of an application for extension.
By them.
By them.
Posing as attorney of my attorney, though the power of attorney has expired. Page 130, your lordship finds that relevant power of attorney. 127 is it begins, 130, your lordship finds. Because to act as an agent, my lord, they require some document, my lord, which is a private contract of agency with a specific time period.
Initially, it was extended on.
That is also beyond, appears to be that because we don't have those documents, you know. Because if it's for 1 year, then it expires on November of 24.
Now, in view of the prayer made in the suit.
Yes.
For specific performance.
Yes.
Right.
Yeah.
And now you are disagreeing with this impugn order. It goes contrary to each other.
No, my lord. What happened next is my suit has been rendered infructuous, my lord. Not just this permission, they registered the sale deed with on a presentation by the attorney on the basis of this order. Because, my lord, they can extend an approval.
Then at this stage it will be difficult.
My lord, this is the stage.
Where is that registration was sale deed?
Sale deed, your lordship finds at page 265. Now, your lordship will mark here, APJ, this flouts all rules of registration also, Registration Act also, my lord. All 265. Now, APJ here again is shown to be represented by Devansh Keshan, who is the power of, who was appointed as the attorney by virtue of that expired power of attorney. Now he shows this order by the Deputy Commissioner extending the validity of the power of attorney.
When it was registered?
It was registered on 1st of January 2026, and the day prior we lodged an application before them that you can't extend this particular authority and therefore don't accept any document for registration. And the suit is already pending, my lord. This is taking an unfair advantage with the endorsement of the state, my lord, which otherwise they could not have done.
And this sale deed should be subject matter of challenge.
Definitely, my lord. But then the state action I have to challenge because I'll show from the statutory provisions, my lord. All of that has been flouted by the registering authority and the Deputy Commissioner, my lord.
Okay, let us examine, but in the meantime, sale deed has been registered.
Yes, my lord. Now, my lord, because they have a subsisting power of, I mean, they claim to have a subsisting power of attorney because of the impugned order, and with that, they can again transfer, retransfer, again apply for mutation, transfer, my lord. When on the face of it, my lord, if I may just elaborate on this, my lord, there are two stages of the illegality, my lord. Firstly, my lord, they could have extended the approval, no problem with that. How
So
can-
your fear is regarding further alienation of the land by the respondent,
Yes.
number 6.
Yes. My lord,
Right, on the
yes.
basis of the sale deed, they have already registered.
Yes. Yes.
That whether this question, this thing will examine. Okay. So we can only pass an order that the respondent number 6 shall maintain status quo, meaning thereby there shall not be any alienation on the basis of the registered sale deed. That much should be. Otherwise,
Otherwise, my lord, and I'll confine only to that.
and that matter, that will be subject to
Scrutiny.
further scrutiny. And the respondent, it will be open for respondent number 6 to make any application for vacation. Right? Because we don't know,
Yes.
we are passing an ex parte order.
Yes.
Yes, Mr. Is to delegate the power to allow.
And that OM is, Lordship,
that
that
day,
yes. That
we
OM
asked for-
otherwise does not provide powers for extension at all.
this is already there.
Yes. I think it's
512 is already there.
yes, because the impugned
But
order-
government letter bearing 10/12,
Yes.
2025 and NOC dated 15/12/2025 as reflected in the deed of conveyance dated 31/12/2025 and registered on 1/1/2020. Yes, any document?
My lord, no.
Where is Mr. Das?
Must-
And Das?
Das lordship lacks in, on if he is in some other court.
Let him come and Das. If he has got it,
Lordship.
thereafter we'll pass the order.
Yes.
Because the matter was heard with in his presence.
Yes, I'll say.
We'll order.
Item number 7.
May I please, Your Lordship, item number 7 and 8, kindly pass about the matter for the time being. My senior is like.
Yes, have you got?
Yes, Your Lordship. Lordship had directed me to
Yes, please.
finish the Basundhara, Your Lordship. All the three
I'm ready.
teams are there, Your Lordship.
Perfectly. Yes.
Yes, Your Lordship kindly peruses page number 3.
Page number 3.
3. There, Your Lordship, it is stated that this
Yes,
is
sir.
regarding Basundhara 2.
Notification dated 15/10.
Yes, 15/10/2020.
Second upon approval of the so and so, the government is pleased to roll out 3 services of petition perpetually. For these services towards purification of land. For transference of land from land for and got by ownership right to community.
Basundhara 3, Your Lordship will find last 2 pages, Your Lordship.
Last 2 page. Yes.
Everything needs to be done through the Seva Setu portal, Your Lordship, online.
But this, whether he can apply after rejection of his
Yes,
application,
Lordship, yes.
where is
That
where is the
telephonic
provision?
instruction I have, that's not given here, but telephonic instruction I have. After rejection, he will have to reapply, Lordship.
And in the notification, last 2 page, timeline for application for submission of the services is from October 2024 to December 2024.
Midnight.
That
In this case, it will be his second, I guess. The first got rejected. First application got rejected. So he has got a reasoned order. Online, Your Lordship, the problem is they don't
this
have
does not appear to be region order.
reason, or because online, Your Lordship, it's not possible to write all the details. Your
Right, but
Lordship.
regional order has to be furnished. If portal,
Yes.
it is difficult to give the entire regions.
Yes, Your
So it is required to be furnished to the applicant. But it is not there. But anyway, if whether it is still open for him to make an application
Yes,
for
telephonic.
settlement of land in his favor under Mission Basundhara 3.0.
3.3, yes, Your Lordship. Telephonically, they said that he needs to reapply.
But after that, he will make an application, portal is closed. Then, if you get a written instruction, it will be better for the court to dispose of all these applications. Right. Otherwise, this notification says timeline is up to 31st December.
Midnight.
On the other hand, you say that otherwise we have to proceed with this application, whether this application has been correctly decided or not. But if it is open for him to make an application, then he will have a life to make an application. Thereafter we can decide. So if you can get the instruction, then I can dispose of all these applications, written instructions that they are, once an application is rejected, it is still open for him.
Written instruction,
Then we can dispose of all this. There are many applications.
Telephonically, they have said that if they can reapply once it is rejected.
Get a written instruction so that
Yes.
the burden is out of your shoulder.
Yes, sir. Yes.
It will be beneficial for you also.
Yes, sir.
Some message, my lord, when the application was rejected, they have been sent the, my lord, the message to the, my lord, concerned mobile number. And lordship, may I kindly see the petitioner number is different.
Page
Petitioner
25.
number is different. Petitioner mobile number, lordship, kindly paste onto the page 11, lordship.
Page 25 and page 11, Your Lordship.
Page
The numbers are
Page
different.
11.
Lordship. Our mobile number is, lordship, the 98646. And lordship, may I kindly see the
Page 25.
The mobile number is different.
Different.
So any communication has been made by any message has been sent to the my lord, this number.
Yes, Your Lordship.
So the petitioner could not be received. My lord. This number is 757.
This has been communicated, Your Lordship, on this number available at page 25.
I have seen the same region in all the writ petition listed before discourse. Same region.
The petitioner
It
needs,
is in which district?
this is
The Dhubri, lord.
Dhubri
Dhubri.
district.
Level lord, the concerned district officer also told me that my lord, due to my lord, that changing the phone number, my lord, they could not, my lord, they received the any my lord, that message, lord. Then they oppose this on our control.
Because who has to decide this application?
My lord, this
District
Circle
commissioner.
officer, Your Lordship. Rejected by circle officer. It is there at page 26.
Where is it? Basundhara 2? Who has to decide? Notification,
Basundhara to Your Lordship.
land policy, laws, also. Contempt. I think it is the district commissioner who has to decide.
My lord,
District commissioner.
Yes, point 14, your lordship.
Point 14.
Yes,
So he has acted on the basis of a circle officer report,
yes, your lordship.
right?
Yes, your lordship.
So the manner of disposal is not correct, but whether it is open or not to, because it was rejected when?
it is rejected, my lord, on
Long back,
23.
2023. You were
Yes.
coming back after 3 years.
My lord,
Yes, your
the
lordship.
thing is that there.
That is why I am
My
asking
lord.
the council whether it is open for the petitioner to make an application under mission Basundhara 3.0. If it is open, you can make an application.
3.0 already been.
That is what,
closed to this.
but verbal instruction,
My lord.
Madam Bodole has received that it is open. So let her take written instruction. Then we'll discuss.
According to the scheme, it is closed, your lordship.
Yeah.
Lordship has rightly said, your lordship.
So to make of the burden from your soldier, if they have telephonically informed you, and that is, it can be still open, then get a written instruction.
Yes, sir.
Otherwise, you will examine this reasoning.
Yes.
Because district commissioner was supposed to pass an order. He says simply rejected.
Rejected.
And what is the reason? On the basis of circle officer's report. Meaning thereby there is no application of mine on his part. Prima facie.
On the other hand, my lord, no notice, no hearing.
He cannot delegate the decision-making authority to circle officer when Mission Basundhara says in paragraph 14 that district commissioner has to do.
Yes.
And land policy also says district commissioner. Assam Land and Revenue Regulation also says district commissioner. That is why. So if it is open for a petitioner, then okay. So have you understood the instruction?
Lordship
Mr.
mentioned it in the order, your lordship.
Mr. S.C. Das, প্ৰথম লাইনটো লিখি দিব, মিষ্টাৰ এইটো লিখিব J. Handy, Learned Junior Government Project for the response number 3 and 4. In deference to the order dated 4/5/2026, Ms. Bodole has placed the notifications pertaining to Mission Basundhara 2.0 and Mission Basundhara 3.0. On as regards the query of the court, whether after rejection of an applicant's application for settlement of khas and civils sealing surplus land, under Mission Basundhara 2.0, it would be open for an applicant to submit a fresh application under Mission Basundhara 3.0. Ms. Bodole has submitted that she has received oral instruction in the affirmative in that regard, post op. However, no written instruction has been received till that post op. Ms. Bodole has sought listing of the case to on after 1 week in order to obtain written instruction as regards the aforesaid query post op. List the case on next Monday.
Lordship, yes, your lordship. Lordship, on last occasion, I was only asked to produce the Basundhara schemes, your
Oh, it
lordship.
is there.
So lordship, in
No, you have submitted.
2 days.
I have recorded.
So lordship.
I have recorded. Learned counsel for the respondents have submitted that even after rejection of the petitioner's application for settlement of khas and sealing surplus land under Mission Basundhara 2.0, it is still available
Yes, your lordship.
for the petitioner to submit a fresh application under Mission Basundhara 3.0. So that is why, which scheme is presently in vogue, I have said. Now here it is closed, it is 31st December 2024, as per the notification. Now, you have been informed orally. Let them instruct
Lordship,
Otherwise, you'll be in difficulty. Only
Lordship,
for that purpose. If they say in writing, no, it is not open, then we'll proceed with the writ petition.
Lordship, may kindly note, your Lordship, the phone numbers are different, your Lordship. So
That is a different matter. We are simply on the question whether it is still open for them.
that I'll obtain.
So make an application under Mission Basundhara 3.0. Otherwise, we will go into the merit of the
Yes, sir.
each case.
They have come.
Otherwise, we will allow them.
The two-
Because he has come after 3 years.
Yes, your Lordship. And
All these 3 years, the petition was sitting,
phone numbers are also different, your Lordship. Maybe it was communicated.
maybe.
21 also same issue.
21 to 21.
Okay.
7, 8 and 21.
8 to Duke.
8/21.
Lays the case on same day.
1805.
Mr. S.C. Das, petitioner, again likhi dibo, lays the case as sought for by the learned counsel for the parties on so and so, as instruction to be placed in respect of WPC number item 7 would cover the present case also. Same. S.C. Das, petitioner, item number
21.
21, and Bordoloi 1 and 2, J. Henry 3 and 4. Same, huh? Overkin.
Oblige.
I think I have posed a query
Lordship,
on the previous day.
Lordship, in this regard, I'd like to place the orders passed by this Honorable High Court. Wherein Lordship, although appeal was dismissed, but for extending substantial justice, the matter was remanded back to the assessing authority. These were in respect of cancellation of the GST registration.
That is a different.
Lordship, their appeals were also filed and appeal was dismissed on limitation, but for extending substantial justice.
This is why I had, in my orders, I had carefully kept it aside because that power is otherwise. But anyway, you give it.
Lordship. And
the authority I had indicated to you,
Lordship, because in this
the authority I had indicated to you was also specific to the
Half number item.
Value Added Tax Act and what is this? Central
Sales Tax Act.
Same.
And otherwise also the same petitioner Lordship has also approached in another week.
Being non-submission.
Otherwise, Lordship, the same petitioner for different assessment year. In that also notice has been issued, this appeal was dismissed on limitation and the notice for assessment has been issued, Lordship, this matter.
I don't think these are applicable. There is no reasoning. But when a specific case is there, I thought that it would be under a different act. Now it is same act. Okay. Some Gujarat or some other act, Value Added Tax Act, read with Central Sales Tax Act. There the assessment was done.
Lordship.
Have you gone through it?
I have not
Then-
come across with the Gujarat High Court order, Lordship.
No. When Supreme Court is there, why Gujarat High Court? No necessity to go through all this rigmarole. Have you?
The Supreme Court order, Lordship, which I have gone
No,
through.
none of you.
Lordship, Lordship has stated about GlaxoSmithKline.
Yes.
In that case, it is there, Lordship.
In that case, Lordship.
In that case, yes, what has happened in that case? Please.
That case, Lordship, the petitioner has approached against the appellate order, which was dismissed on limitation. Honorable Supreme Court had said that because it was dismissed on limitation, it is statutory power, so it cannot be condoned. So that was the finding to that effect. But in that case, what had happened? The petitioner had gone before the higher court against the appellate order, which was dismissed on a limitation. My submission is that in the present
Not, sir. Not, sir. Let us have then. If you want to dispute it, then let us have this.
I'm disputing, Lordship. What
Let us have this then, facts of the case, please. Asif. Let us have it. What is the question framed?
Lordship, in that case,
Para 1.
after something.
Para 1. Okay, I'll give you time. Let us have the question framed and answered by the Supreme Court. Whether the High Court, in exercise of its writ jurisdiction, under Article 226 of the Constitution, should entertain a challenge to the assessment order on the sole ground that the statutory remedy of appeal against that order stood foreclosed by the law of limitation. Right. Shall I read again?
No, I will.
Right. This question has been framed again in a different paragraph. In the backdrop of these facts, whether the High Court ought to have entered in the writ petition filed by the respondent. Another question. As regards the power of the High Court to issue direction, order, or writ in exercise of its jurisdiction under Article 226 of the Constitution of India, the same is no more res indigra. Even though the High Court can entertain a writ petition against any order or direction passed or action taken by the state under Article 226 of the Constitution of India, it ought not to do as a matter of course when the aggrieved person could have availed an effective alternative remedy in the manner prescribed by law. Thereafter, it has gone on to discuss this and thereafter finally said, once an appeal is beyond the normal period of limitation and extended period of limitation for the tribunal or the appellate authority to condone the delay beyond that period, then High Court under Article 226 cannot condone that delay and thereafter examine the merit of the assessment order. And it has gone on to say, not only High Court, we also don't have any power under Article 142, even to extend substantial justice. Now I checked whether it has been reversed, this decision. Any contrary view is taken. I don't find any. So in that background, whether because this appellate authority said it is beyond 1 year.
Yes.
And ordinary period of limitation is
60 plus 30. Originally 60, extended 180.
100. No ordinary period of limitation?
60.
And extended, permissible extended period?
180.
Up to 180. Total 180.
Yes.
Let us see. Assam Bhelweder. Yes, mister. What is the provision?
Section 79.
79. Mr. Todi, I am asking you because so was some contrary thing. Otherwise, I have to go by the authority or the Supreme Court. There cannot be any exception. What is the first period of limitation? 79.
What?
Any person aggrieved by an order under this act by the legislature lower in rank of deputy commissioner may appeal to the so-and-so 60 days.
Then
No appeal by a person shall be entertained by the appellate unless such appeal is accompanied by satisfactory proof of payment of 20%. Subsection?
subsection 2. Lordship is reading section 79.
Yes.
Subsection 2.
Subsection 2. Is satisfied that the is prevented by sufficient from presenting the appellate. So 180 plus 60.
240 days.
240. Now your case is?
My case is beyond 240 to be admitted on facts, Lordship.
For filing of appeal under GST Act, this second paragraph is wrong. 30 days. Page 24. Page 24. Second paragraph. Fourth line.
Yes, Lordship.
30 days.
Is it incorrect?
Lordship, to my knowledge, it is incorrect, Lordship, because I couldn't find out in the rules also this for the 30 days.
So let us assume 180 days.
180.
180. 60 plus 180, 240. Now third para. First line. It is beyond 1 year.
Beyond 1 year.
So 1 year is more than 240 days.
240.
So whether he does not have any power to condone the delay. If he has no power, whether under res jurisdiction, this is a precise question which was framed by the Honorable Supreme Court. If there is any contrary view, please tell us. Otherwise, this is to be dismissed in limine.
Lordship, I will submit in a...
I am giving you time, but don't show me revocation of GST cancellation. When this is a case under those, because my orders are different in GST cancellation. Mr. Chaudhary, you have seen. But so far, these orders I am not, when the Supreme Court order is there.
Lordship, in other case, I have...
Show us any authority of Supreme Court.
So far, this order...
Because this order has clearly says that is Andhra Pradesh Value Added Tax Act.
Yes.
And read with Central Sales Tax Act. They were involved in sale of Horlicks, Boost, biscuit, ghee, Ayurvedic medicine. Same thing. For had called upon the respondent to produce books of accounts. Blah, blah, blah. Then after that, raise demand.
Yes.
In your case, 3 so-called notices.
That so-called notice was not in terms of the section, Lordship.
These are all subject matter of appeal. These were all subject matter of appeal.
But the Lordship, when appeal
No, when the law it says, law says.
Appeal was dismissed on limitation, the assessment order doesn't get merged with the appeal order, Lordship.
It is there, clear. So, but High Court, that is what I have seen, sir. Long judgment. It is well settled that rejection of delay application by the appellate forum does not entail the in merger of the assessment order with that order. They have clarified the situation. Then, taking any view of the matter, therefore the High Court ought not to have entered the subject petition filed by the respondent herein. The same deserved to be rejected at the threshold. Para 24 and 25. They have clarified. Go through it.
I'll go through it.
Try to differentiate tomorrow. Will not keep it pending. If you can show us,
Can it be there
show
for
us.
tomorrow?
No.
Tomorrow, Lordship, I have matter before Honorable Supreme Court. I'll be appearing online.
Okay.
Day after tomorrow.
Mr.
Yes.
Sorry. I heard Mr. Dr. A. Todi, learning counsel for a petitioner, and Mr. B. Choril, and standing counsel, Finance and Taxation Department for the state respondent. Full stop. Release the case again on Thursday.
Much.
Show us anything contrary.
Lordship, I'll try my best.
Otherwise, our hands are also tied. We cannot go beyond as on the situation existing.
Much.
Item 10.
Yes, state.
Lordship, we have received the instruction, Lordship.
Yes, please.
One Nazimuddin Ahmed has lost and written FIR, Lordship.
On Najimuddin Ahmed. 1 minute. Just a minute. Ramjan, I think. On the basis of a FIR by Najimuddin Ahmed.
Yes, Lordship.
General Diary entry, Bura OP General Diary entry 243 dated 14/4/2026 was registered. Then preliminary inquiry was initiated. Thereafter, Sipajar Police Station case number 68/2026 under various provisions of BNS has been registered on 6/5/2026.
Yes, Lord.
Will record in the order?
Yes, Lord.
I will close this. Heard Mr. G.R.A. Mobarak, learned counsel for the petitioner, and Mr.
H.K. Hazarika.
H.K. Hazarika, learned junior government advocate for all the respondents. Full stop. Para. The petitioner has instituted petitioners have instituted this writ petition, stating inter alia that they are being harassed. No, they are.
Except the petitioner number 4.
There is an existing family dispute with regard to partition stroke share in the property between the second son of the petitioner number 1, PIZ Najimuddin Ahmed, and another son of the petition number 1, that is the petition number 3. Full stop. The petitioners have referred to an incident occurred on 14/4/2026 as which had aggravated the existing dispute. Full stop. The petitioner, with regard to the said incident, the petitioner, number 4, lodged a first information report FIR before the officer in charge Sipazar police station on 15/4/2026. Full stop. On the other hand, full stop. However, the petitioners are being looked for by police personnel on the ground that another FIR has been registered against them. Full stop. As the police personnel from Sipazar police station declined the request of the petitioner to disclose the details of any general diary entry or FIR, as the case may be, registered against the petitioner. The petitioners have approached this court by the instant writ petition, first up, on 6/5/2026, the State Council was requested to obtain instruction from the respondent number 2 and 3, whether any general diary entry or any FIR has been registered against any of the petitioners herein. Full stop. Mr. Hazarika, learned junior government advocate, has submitted that he has received instruction from the SP Office of the Senior Superintendent of Police, Dorong, Mongoldoy, by an office letter number so and so dated 9/5/2026, and he has placed a copy of the same before the court, as he has the authority to place so. From the instruction placed through the office letter dated 9/5/2026, it is noticed that on 14/4/2026, one Najibuddin Ahmed, a son of the petitioner number 1, had lodged a written FIR at Bura Outpost, BURHA Outpost, under Sipazar Police Station against, in respect of an incident of alleged unlawful restraint, assault on him and his family members by the accused persons. 1, Sainu Begum, wife of Abdullah Haq; 2, Abdullah Haq, son of Ramjan Ali; 3, Afrina Ahmed, daughter of Abdullah Haq; 4. Fulbahar Begum, wife of Ramjan Ali, and Ramjan Ali, son of late Nirmal Sikh. Post on receipt of the written ejaar, a general diary entry, general Bura OP ZDE number 243 dated 14/4/2026 was registered and preliminary inquiry was initiated immediately. Post up. On the basis of the inquiry conducted, the FIR was forwarded to the officer in charge Sipajar Police Station for registration of a regular police case under appropriate sections of law. Post up. Thereafter, the officer in charge Sipajar Police Station registered the FIR as Sipajar Police Station case number 68/2026 under sections 74/115 within bracket 2/117 within bracket 2/118 within bracket 2/3 within bracket 5 of the Bharatiya Nyaya Sanhita within bracket BNS 2023 on 6/5/2026 and endorse the case to a sub-inspector of police and in charge Bura outpost for further investigation. Post of that are in view of the same, in view of the registration of the, in view of the above details, it is for the petitioners to seek appropriate remedy permissible under the law. Post up. And post up. Therefore, the writ petition stands closed, reserving the liberty to the petitioner to seek appropriate remedy available to them under the law.
For one line, Lordship. Police authority will proceed subject to the provision of section 35.
That is not required.
Daily list, item 11.
What is the other matter?
Other matters in this page is code number
19
today itself.
Oh.
That case, my lord,
13 to 22 of code number 19, your lordship. The series
Okay.
has been listed. There the.
The video has been filed there.
no instruction, my lord. The last chance was given lordship.
It's fixed on 28, your lordship.
28
May. In this
of
case,
this
no-
month.
Yes. My lord, in this case, notice may be issued and. fixed on the-
28, returnable 28. Heard Mr. M.H. Ahmed, learned counsel for the petition. Mr. Hazarika,
Correspondent number,
initial.
Hara Kumar Hazarika.
Hmm?
HK Hazarika.
Junior government advocate for the respondent number 1, 4, 5,
6 and 7.
6 and 7, Miss Ann Bordoloi, learned standing counsel, Revenue Department for the respondent number 2 and 3. Full stop. The learned counsel for the parties have submitted that the subject matter of the writ petition of this writ petition is similar to the subject matter of the writ petitions WPC number 4181.
4181.
2023. And the said and the repetition WPC number 4181 2023 is ordered to be listed on 28/5/2026. First of let notice be issued. The notice is made returnable on 28/5/2026. First of as Mr. Hazarika and Ms. Bordoloi accepted notice. Formal notice dispensed with. Extra copies within 2 working days from today.
Extra copies here, my lordship furnished on the last date, lordship.
2 copies each.
Today are all respondents, lordship.
2 copies. 2 extra copies.
Obvious.
2 copies.
13,
Right, please, your lordship.
Hmm,
The petitioner before your lordship has, the GST registration of the petitioner has been.
39, failure to give a reply. To appear before undersigned. Yes, Mr. will dispose of.
Lordship.
Dispose of.
Deeply obliged.
item 15,
Yes, madam.
Good morning, Your Lordship. Your Lordship, this is a case wherein arbitrary deduction of amount of rupees 8 lakhs approximately has been deducted by the respondents.
Similar order has been entered, similar petition has been entered in Mr. Sharma.
My lord, there has been 2 rounds of litigation on the earlier occasion. Now, my lord, your lordship will kindly come, the last repetition in this regard, my lord, page 83. Page 83. It's the latest order, my lord, of a coordinate bench of this court.
Will you issue notice?
You'll issue notice, ma'am.
Your Lordship, this is another petitioner. The respondents are the same. We are another petitioner, and in this case, there is another petitioner. The matter is similar, but Your Lordship, in this case, I have another prayer. Your Lordship, the respondents have been time and again very blatantly violating the orders of the Honorable High Court. If you will refer to page number 65, it will be 62 to 65, it will be clearly evident that despite of repeated orders of the High Court and repeated requests from our side, they are clearly violating it. So, Your Lordship, my sincere request is that the amount of money that they have deducted, Your Lordship, it is a very hard-earned money. It anyway stays with them only, that in case I am found to be guilty, they should definitely deduct it after the end of this, after the petition or our matter is disposed. Your Lordship,
Neither of the parties is poor person. We should notice. Petitioner is not a poor person. Heard Miss
Poddar.
B. Poddar, learned counsel for the petitioner, and Mr. M. Sharma,
My lord,
learned standing counsel,
1, 2, 3, 4, and 5, my lord.
Indian Oil Corporation
My
Limited, for all the respondents.
My lord.
First of para. The petitioner is aggrieved by a direction made by the respondent IOCL
My lord.
authorities to refund or reimburse amounts of rupees 5,81,030 and rupees 1,99,933.
My lord.
Comma, that is, comma, rupees 7,80,963 from from pre-authorized debit balance PAD account of the petitioner. Full stop. The genesis of the direction is related to a show cause notice dated 18/2/2025.
Yes, Your Lordship.
First of, Mr. Sharma, learned counsel for the learned standing counsel IOCL, has submitted that in a similar petition, comma, notice has already a similar petition WBC number 2136/2026. Notice has already been issued. So the said fate is also agreed by the learned counsel for the petition. First of, issue notice returnable on 15/6/2026. As Mr. Sharma has appeared and accepted notice on behalf of all the respondents, Issuance of formal notice to the respondent is dispensed with. The Constable of Petition shall furnish requisite number of extra copies of the writ petition to Mr. Sharma within 3 working days from today. The respondent shall ensure that its affidavit, its counter is filed on or before 10/6/2026. Post of any further amount. Para. It is observed that any further amount deducted pending notice shall be subject to the outcome of the writ petition.
Your Lordship, no reimbursement, Your Lordship.
You'll get back if you are successful.
Thanks, Your Lordship.
16.
My views. My lord, petitioners are siblings, my lord. Praying for.
Owners of possession plot 4 kata so and so covered by so and so. Yes, is it a public service?
Lordship.
Have they filed in proper form?
Page 16, my lord.
It was not in a proper form, but application is filed. But it was not in a standard form. Lord. This is an application. I have to.
There is a requisite fees also required.
It was not from this application. It was not seen that it.
We have passed many orders earlier.
Lordship.
Let it be in a proper form.
Yes.
Public service, why writ petition? Yes, Mr. Counsel.
My lord, we thought.
Demarcation is a notified public service.
Yes, it's my lord.
File it properly.
My lord.
Then if they don't pass, yes, notified demarcation also heard Mr.
Ahmed, my lord.
SS Ahmed, Land Council for the petitioners. All are from the same family.
Same family member.
Okay. Ms. N. Bodole, Learned Standing Council, Revenue Department for the respond number 1.
2, 3, and 4.
SS Roy, Learned Junior Government Advocate for the respond number 2, 3, and 4. Full stop. Para. The petitioners, comma 18 number, comma, have stated that they are from the same family and successors in interest of one late Bidu Uram.
Yes.
Okay, first off. The petitioners have stated that they are, by virtue of inheritance,
My lord.
they have become owners of a plot of land measuring 4 kathas, 13 lessas out of a parcel of land measuring 1 biga 4 kathas, 6.94 lessas, comma, covered by KP Patta number 61 and Dag number 307, comma, situate in revenue village Uloni, comma, Moja Dimoria, Punapur Revenue Circle, District Kamrup Metro Assam, subject plot. Post up. The petitioners have further asserted that they are in continuous possession of the subject plot and by a mutation order dated 21/5/2025, comma, the subject plots, the names of the petitioners have been mutated in respect of the subject plot. First of, the petitioners have also stated that they are regularly paying land revenue in respect of the subject plot. First of, para. The petitioners have instituted the instant writ petition, stating that due to non-demarcation of the boundary of the subject plot, comma, difficulties are being faced to erect fencing in the boundary of the subject plot. Full stop. The petitioners have stated that a representation dated 3/2/2026 was filed before the respondent for seeking demarcation of the subject plot, post of, as the representation of the petitioner has not been given due consideration till date. The petitioner stated that as a representative so and so had not been given consideration, till date. The petitioners are compelled to approach this court by the instant repetition seeking a direction to the respondent authorities. For demarcation was subject plot forthwith. Full stop. Para 5 পৰা লিখি দিব নামকেইটা চেঞ্জ কৰি দিব File an application as per the prescribed form.
Small prayer, my lord. One small observation may be made, my lord, that in the event of filing a standard application, my lord, that may be considered as per the time period laid down in the RTPS.
Yes, already there it will be there in the order.
Within 30 days.
It will be there in the order.
Item 17.
Yes, ma'am. Similar case, PHU है ना दोगी? PHU है. किस नंबर की ना कोई डिले? Electric district for these.
Eviction already occurred.
Yes, sir. Since the day of eviction, as on today, they are staying in makeshift camps without the basic amenities of life.
So you want a similar this thing as per the similar direction.
Yes, your lord.
Page 94.
Yes, your lord.
Yes, Mr. Bothagur.
My lord, there, my lord, the situation was different, my lord. The petitioners were all, my lord, concentrated in one area. When, my lord, they were first, my lord, they were not evicted from forest, my lord. They were evicted from wetland. Here, my lord, they were evicted from forest. Second, my lord, these petitioners, they were concentrated in one area. That is why, my lord, this honorable court thought that since they have already been settled by the state, now they needed to be given that sanitation facilities and everything. Here, my lord, we don't know where the petitioners are because from the pleadings, it looks like they are scattered. So first, my lord,
They are staying in some private lands, lordship, making some makeshift camps. Where basically the eviction is not an issue here. It has already occurred, your lordship. The issue before your lordship is we are seeking a direction for protection of our fundamental right, your lordship. Basic amenities of life. Eviction has already taken place, your lordship.
Lordship, addresses are not given,
Yes.
lordship, properly. Kindly
It-
peruse
it-
this page number 6.
They are
and
staying in the same place. Kindly come to page number.
The petitioner's address are not mentioned, your lordship.
Where are you staying present?
Kindly page number 14, your lordship. All are staying in the same place. Your lordship.
Page 5, your lordship, no address.
Page 14. No, those are your
All are residents.
residents where from you have been evicted.
Yeah.
Right?
No, at present, we are there only because we have no other land to go, your lordship. We are occupying some private
No,
lands, your lordship. Out of humanitarian grounds, some
No,
land.
what are those lands?
They are private patta lands. They have out of humanitarian grounds. They have allowed us to stay there.
Where have you said specifically that you were staying in Patta lands and in villages.
Paragraph 9, Your Lordship, page
Huh?
number 19.
64.
Paragraph 9.
Yes, Your Lordship.
উডমাৰী, পশ্চিম যমুনা গাঁও, পূব যমুনা গাঁও। Patla
That is the place where they were evicted from, my lord.
No, they are saying that makeshift camps in Miadi Patla land,
Hmm.
not your land. Paragraph 9.
Presently listen.
They are saying that they are not in occupation of the lands wherefrom they are evicted. They are in occupation of, they are staying here, there in Miadi Patla land, belonging to persons of nearby villages. So, perhaps these are adjacent villages.
Yes, Your Lordship. Nearby village.
Instruction from the district administration, my lord, will be required.
Actually, they
Yes, whether, yes, my lord, whether they're actually there or not.
56, 57, we have annexed the geomap photographs, Your Lordship.
Cow. The Pellegrini cow, yes. John Paiga.
56.
Yes, Your Lordship, page number 56.
55, 56.
they are getting they are having ration cards. They might be getting it, Lordship, really.
You can go and collect the ration.
Lordship. There's the ration cards are given there. If the case of
You have been denied
that
for grains.
Because we are evicted, we are staying somewhere else. So we'd say, let the government file an affidavit that they're regularly providing us.
Instruction, Lordship, whether they are actually staying there or they are.
No, where is the statement that you have not been provided ration?
Paragraph 23, Your Lordship, case number 27.
ration card আছে
Down to page 100. Direction number 2. If you are in the adjacent villages, where is the difficulty of obtaining the food grains from the fair price of in question?
Because the lordship, once the eviction has taken place, these people are they are morally totally their psychology, everything has gone, your lordship. So we are before your lordship.
No, that is a different psychology is different thing. But whether they have been deprived from the ration from the fair price of as per their ration cards.
Due to this dislocation, they are not able.
Dislocation is not much, I don't think. Para 9 you says that they are adjoining villages. Adjoining villages. Where is the difficulty of getting the food from that ration from the food grains from the nearby the ration fair price shops?
Actually, they.
It is not that the fair price shop owner will come and deliver it to you. Because he has hardly 20-30 paisa per kg. It is not possible for him. So, if you are adjoining villages, what is the difficulty of getting the food grain? If you are denied, that is a different issue. But there is no statement. But this paragraph 23. Displaced and vulnerable person under National Food Security Act. Yes, it is an interim order.
No, but my lord, there was circumstances are different, my lord. Their place was identified, and my lord accepted by the government. My lord may
Let us see then. Let us then examine each of the case. Where is the notice for eviction?
Page 52, your lordship.
Yeah, all.
Dear Reserve Forest.
Look to my reserve forest.
Wetlands. Petition হচ্ছে তোমার ইমান দিন
Is there any provision for rehabilitation for persons who occupied reserve forest areas?
Lordship, we are basically river eroded landless people. We have no other place to
Sorry,
go.
where is the evidence of river eroded? That is the common statement I have seen in every case. River eroded without any semblance of any evidence. River erosion people is issued certificates that these are river eroded people. Right. River eroded people must have land ownership and their lands are eroded. Even if by alluvion or diluvian of river, their lands are gone, but piece of paper must be there.
Yes,
That evidencing that yes, once upon a time, they had a piece of land which has been eroded. Right. If that document is available, then yes, we were termed as a river eroded people. If their land is gone by process of river erosion, right? Mayor making a statement because I have seen in all the cases. So that question has cropped up in my mind that how a person can be declared, right? So the mayor making a statement, bold statement that river erosion people, thousands of people. It is not that. Making a statement will not do.
Yes, Your Lordship.
Yes, but you should have provided some basic amenities.
My lord, there's a land rehabilitation policy of 2019, my lord. They have the liberty to approach through that policy. Then it will, my lord, receive consideration.
Let us see what is your stand in the other one also. What was the stand? It was what is the stand in the other one?
In that case, my lord, we from PHE department, I was there for PHE, my lord. Forest is not a party in this case, my lord. We'll see because they were not evicted from forest. From PHE, my lord,
They are evicted from forest only.
These petitioners, but not this one, my lord, which they have relied on. Triple eight of
that is wetland.
Yes,
That is wetland.
In that case, my lord, they were specifically identified. My lord, will see at page 95.
That is a particular plot of land, compact.
Compact plot of land, 566 families. My lord, they were identified specifically by district administration, and so then, my lord, PHE department has provided temporary, my lord, toilets as well as water facilities for them. But first, they have to be rehabilitated, my lord, properly by the government somewhere. Then, my lord, the other things will follow.
The question remains, Your Lordship, until and unless a rehabilitation plan is there. This
Which policy has provided for rehabilitation?
There's a 2019 policy, my lord.
That is land policy.
Land policy. Under that
provides, yes, Mr. Borpujari, that provides for rehabilitation.
Rehabilitation, my lord, provides only this if they are, my lord, naturally affected, some persons are there. Here is a case where they have voluntarily gone into a.
If by the fury of flood,
yes,
if they are displaced, then there has to be rehabilitation. Right.
By act of
yes, by land, their lands and belongings have been affected, or by say release of water from a dam, it is flooded. They have to be rehabilitated somewhere for the time being. But these are encroachers, termed as an encroachers, and they are being evicted by process of law.
Absolutely, yes.
Right.
Yes.
So where is the process of rehabilitation plan?
Nothing
Is there
as such.
anything in place?
I do not find anything. It is for the petitioner to, my lord,
Yes.
establish before this honorable court that these are the specific provisions by dint of which we are required to be rehabilitated. Definitely, we will bow down, my lord.
Okay, you can provide us the actual compact plot of land, patta land and dag number. We may make provision for water and all. Just give a statement because this is a vague statement. Paragraph 9.
In the writ petition, my lord, it is devoid of material facts, my lord.
The paragraph 9 is not that particularized. Right. If they are there in a compact plot of land, we can ask them to provide sanitation facilities at least. Otherwise, if that facility is not there, Mr. PHE, it will be, if defecation is there all over the place, then all other persons will be affected.
It will become a hazard.
It will be a hazard for all. And this aspect is to be looked into also somehow. That if they defecate in any other areas, open areas, then everybody else will be affected.
Because my lord,
Right. No, this is a human problem, not only for them, for others also. Some sanitation facility temporary makes it for the time being, and thereafter, but they arrange whether they are entitled for land or not, that is a different matter. But ultimately, it is human under the open sky. So let us have something, but you have to give us something. State machinery cannot be used for that purpose. Yes, had you been a landowner, by flood, by something, you have been affected, then there is a rehabilitation under the law. Right. Olga Telis is regarding dwellers on the footpath. Everything cannot be mixed into everything, but you have a peculiar situation.
Yes,
so let us have the compact plot of land where you are presently located. If we can, then only we can ask. Because if all the 88 or 90% families are there,
more than
if
250 families staying there, Lord.
then it will be difficult. That state machinery cannot be used for all are living in different patta lands. 250 families living in 100 different plots of land. It will be very difficult to arrange. If it is a compact, then we can think of sanitation facilities in one place. But you are located in 3 different villages. And ultimately public expense. Public expense. And who will bear? The genuine taxpayers. At the cost of genuine taxpayers. That is to be looked into. You are dislocated everywhere. 3 villages. How can the state provide for everybody?
Don't have
No,
any other
optionless, but at the same time, there are 2 sides to the coin.
Yes, sir.
If you are in a compact plot of land, all the families are there, and some makeshift arrangement for sanitation, water would be there. And plus, if you are deprived of a ration card, all these things, all can be taken care of. But officials are not of that strength that 250 families scattered over 3 villages and they would go home by home and provide. It is not all this, what you say nowadays, this thing on a phone call, this Swiggy or this thing.
Instant delivery.
This is not that. Link it.
Lots of present petitioners are staying in the same area here.
Tell me on a specific place.
Village Woodmari.
No, 3. That is what I am pointing out.
Yes.
Show us. Give the details on this tag number, patta number. Then we'll. And if it comes out that they are scattered over 100 ducks, it will be difficult. We may refuse to pass similar direction. We are ready to pass, inclined, provided
We'll find an additional affidavit.
they are located for service at ease. Are we difficult? Yes.
Paragraph 9, my lord, he may file an affidavit, my lord.
And that is what I am.
Expanding the statement made in paragraph 9.
That is what I am indicating to him.
They say, my lord, post eviction, they are residing in Dag number, my lord, Miadi Patta lands. Let him file an
Let him file, then
It will
we'll
give
can
us a hand.
ask.
The landowners are allowed to stay there out of humility and ground lordship. That is the issue.
At least you can make a mention that we are staying here,
Yes.
so that we can ask them to facilitate some service. Heard, Mr.
Z Khalid.
Learned Counsel for the petitioners. Who represents one? Mr. H.K. Hazarika, Learned Junior Government Advocate for the response number 1, 4, and 5. Mr. S. Roy, Learned Central Government Councils for the respondent number 2. Mr. R. Borbuzari, Learned Standing Council, Revenue and Disaster Management Department for the respondent number 3.
my lord.
Mr. I. Borthakur, Learned Standing Council, Forest Department for the respondent number 6.
And my lord, 11 for PHE.
And Standing Council, PHE, for the respondent number 11. Any health? Mr. Bhuya, M. Bhuya, Learned Counsel on behalf of Mr. B. Gogoi, Learned Standing Council, Health and Family Welfare Department for the respondent number 7, 8. 7 and 8. And education, Mr. G. Pegu, Learned Standing Council, Elementary Education Department for the respondent number 9. Mr. Hazarika, you present 10 also?
Civil supply.
Food and Civil Supply? 10, huh? H.K. Hazarika. And who represents 12? Mr. Roy?
Water resources.
Is it a state agency or? State agency. Hazarika, 12. Close to. The petitioners, comma 98 in number, comma have projected that they have been evicted from areas allegedly within Jamuna Modanga River Reserve Forest, pursuant to an eviction process initiated by a notice dated 10/10/2025. Most of the petitioners have stated that the eviction process was carried out on 2/1/2026. Because of the eviction process, the petitioners are compelled to take shelter in periodic patterlands situated nearby to their earlier places of residence. The petitioners have stated that presently, they are they are residing in makeshift camps in parcels of land, parcels of periodic patterlands belonging to persons of villages Udmari, Paschim Jamuna Gaon and Poob Jamuna Gaon. Full stop. The petitioner stated that in the makeshift camps, the respondent authorities have not provided any sanitation facility, facilities, we have not provided any facilities like potable water, comma, sanitation, comma, food grains, etc. Full stop. Mr. Khalid, counterpart of petitions, has submitted that in case of similarly situated evicted persons, comma, this court had directed the respondent authorities to provide the basic facilities post of in he has referred to an order dated 18 to 2026, passed in WPC number 888/2026, post of para. The learned counsel appearing for the respondent authorities has submitted that the case of the petition in WPC number 888/2026 are not similar to the case of the petitioners, as the petitioners therein were evicted from a wetland and they had represented that they had taken shelter as a makeshift arrangement in a compact lot of periodic patha land. Post of, however, in the case of the present petitioners, it is evident from the statement made in paragraph 9 of the petition that the petitioners are residing presently at different places in 3 villages, namely Udmari, Pasim Jamunagaon, and Pub Jamunagaon. Post of para. In the order dated 18 to 2026, comma, the court, as an interim measure, directed the state respondent authorities to ensure proper potable water facilities, comma, adequate rations on the basis of ration cards from fair price shops, comma, to extend primary healthcare services and to set up proper temporary sanitation mechanism in the compact plot of land. Full stop. As the statements that the present petitioners are presently residing in periodic patha lands without further details, and considering that facilitation of basic services would require involvement of manpower and other logistics, the petitioner shall file an additional affidavit identifying the areas of land, specific areas of land where they are presently residing. So such affidavit be filed within a period of 1 week from today. Please the case on next Wednesday.
2005. My lord, on
And 2020, my lord, he got the information. And first it was, he was informed that it is an accident, but subsequently.
Yes, Mr. Goswami, it is basically a zero FIR.
That's. The place of occurrence is UP law.
See section 173.
What?
When it was. Provision was earlier also there was in the CRPC. It is to be treated as a zero FIR.
That's it.
And since the place of occurrence is in a different jurisdiction, this FIR is to be transferred.
Yes.
So only thing necessary for you to obtain, whether after registration of this FIR in the year 2020,
Yes.
that has been transferred to the police station having jurisdiction to investigate the case.
Yes.
Nothing else we can do. After it is transferred, that you have to approach there
My lord.
to Allahabad High Court, not to God.
Know about the
Yes,
process.
yes.
I think.
Heard Mr.
DCC.
DCC Fukon, learned counterpart of petitioner.
I for 1
And
to 4.
Mr. N. Goswami, learned junior government advocate for all the respondents.
Yes.
Full stop. Para. The grievance of the petitioner is that in respect of death of the son of the petitioner in an incident occurred on 8/2/2020 within the jurisdiction of French Colony Police Station, Itawa, District Itawa, Uttar Pradesh. In an incident, in an respect of an incident, accident occurred on 8/2/2020, leading to the death of the son of the petitioner on 15/2/2020. Within the jurisdiction of so and so. The petitioner lodged an FIR before the officer in charge, Hadgaon Police Station. And the said FIR had been registered as Hadgaon Police Station case number 49/2020 for the offences under section 279 and section 304 of the Indian Penal Code on 4/3/2020. Post of. The petitioner has approached this court with a grievance that the petitioner has not received any information as regards the progress of the investigation of the case after registration of Hadgaon Police Station case numbers 49/2020. Post of Mr. Goswami, learned junior government advocate appearing for a respondents has submitted that the FIR registered as Hadgaon Police Station case number 49/2020 can, at best, be treated, can best be categorized as a zero FIR. And since the place of occurrence is within the jurisdiction of another police station in a different state, it is a responsibility of the police station who had registered a zero FIR to transfer the FIR for investigation to the jurisdiction police station. Mr. Goswami has sought listing of the case. Hadgaon, so next week,
Let's.
to obtain instruction in the matter from the respondent number 4 and to place the same before the court on Monday. Place the case accordingly on Monday. You want any further information? Only police station case number. Copy of the repetition is not required.
1805. Item 19.
May I please, Lordship? Lordship, matter pertains to account grant, please, Lordship.
Operating any disputed amount.
Number 4, that is branch manager, is not given any details, Lordship, to the petitioner.
Heard, Mr.
Yes, number.
When it comes about a petition. The petitioner has approached this court on the ground that the respondent State Bank of India authorities have kept the bank account of the petitioner. Savings bank account.
Yes, Lordship,
Savings bank account number synopsis maintained by the petitioner at Kolgasia branch, Borpeta, in a freezing condition. Post up. The petitioner's further petitioner gives is that despite request, the reason for keeping the bank account on hold has not been provided the petition. Issue notice, same returnable, 86, returnable on so and so. Steps by speed post within 2 working days from today.
I'm deeply obliged.
Item 20.
Yes, Lordship. Lordship, matter may be possible for the day.
For a day.
Lordship, my senior out of station, then
Okay.
any day.
Which for the okay? Nobody is there. Earlier, some standing houses, Central Bank of India. His name is reflected. Okay, there is a prayer for adjournment on behalf of the petitioner. By Mr.
IOCL on behalf of G.
I. Hussain,
On behalf of G.
Land Council. Post up. Yes, madam. He mentioned it 10:30. You were not there. Yes.
Lordship, I'm in item number 20, Lordship.
Yes. This is 20.
Yes, Lordship, we need some time to get the instructions, Lordship.
Okay, in the meantime, Miss
S. Yasmin on behalf of M. Sharma.
Ms. S. Yasmin, Learned Counsel on behalf of Mr. M. Sharma, Learned Standing Counsel, Central Bank of India, has sought some time to obtain up to the instruction in the matter. Post to release the case on next Wednesday or Friday. Release the case Friday.
Much obliged, Lordship.
2205.
This Friday.
1505.
Much obliged, Lordship.
Item number 22.
How was it? How was it? Yes, madam.
I'm for the department, Your Lordship.
Dutar material tanle. Dutar material. Yes. The other one, 5, no? Who was there? Mr. Das. Das.
I will.
2 then. Item number at 2. And this one also again. Item 20.
Daily list, item 22.
May I please, Your Lordship? Lordship, we come here before a limited prayer, Lordship. We have filed an application for initiation of inquiry, Lordship, before the registrars, Cooperative Society Assam. Lordship, based on the complaint, page 57, annexure 2, Lordship. The deputy district deputy registrar has issued one letter to the directors and president and board of members of the society, Lordship, and requesting them to provide the documents within a stipulated time, Lordship, by 21st August. As the documents were not provided, Lordship, then the district deputy registrar, filed another letter, that is annexure 3, page 58, Lordship, 27 August 2025, Lordship, have issued one show cause notice. Page 58, Lordship, the show cause notice for non-compliance.
Yes.
Subsequently, Lordship, due to some another issue, the board has been dissolved by the registered cooperative societies while ordered it 10/9/2025. That is on page 60 and 61, Lordship. The board has been dissolved and one-man committee has been appointed, Lordship, by the registered cooperative societies Assam. Lordship, subsequently, there is no progress in the inquiry and the inspection. We came here just for a limited purpose to please let us know what is the outcome, Lordship, because they have not done the inquiry or the inspection.
Yes, standing counsel, Corporation Department.
Lord, I will obtain the instructions.
Art, Mr.
A. Kakoti.
Coverage Learning Counsel, what a petitioner. Petitioners. Petitioner. Who is he? Who is the petitioner?
Mr. Ravi Day.
Who is
Page
who
15.
claims to be a member of Messrs. Aria Smart Living Group Housing Cooperative Society Limited. First off, the petitioner stated that on 11/8/2025, comma, the respondent number 2 had ordered the society or sort. The respondent number 2 had ordered an inquiry under Section 87 and Section 88 of the Assam Cooperative Societies Act 2007 into the affairs of the society based on specific complaints supported by privacy materials. Full stop. On nalage 11/8. On 11/8/2025, comma, the respondent number 4 directed the president of the society to cause production of records.
President, members, and board of directors.
President, members, and board of directors of the society to cause production of records and written explanations. Full stop. Subsequently, comma, on 27/8/2025, the respondent of 4 had issued a show cause notice alleging non-submission of records and written explanations pursuant to the letter dated 11/8/2025. Full stop. On 10/9/2025, the respondent number 2 had, by an order of event date, had disapproved the proceedings of annual general meeting of the society, comma, held on 28/9/2024, comma, and dissolved and passed an order of dissolution posted by the said order, one, an officer on management under section 41 within bracket 6 of the Assam Cooperative Society Act 2007 came to be appointed. First up, the grievance of the petitioner is that the petition has been kept in dark about the outcome of the inquiry directed against the society under section 87 and 88 of the Assam Cooperative Society Act 2007. Post of Mr. Your name, please.
K.A. Sodial on behalf of.
K.S.
K.A. Sodial. K.A.
K.A.
Sodial.
Learned Counsel. You are standing counsel?
No, for appearing behalf of S.K. Talukdar.
Learned Counsel on behalf of Mr. S.K. Talukdar and Standing Counsel Cooperative Department has sought for a week's time to obtain instruction as regards outcome of the inquiry system. Procedural is the case on so and so.
With the second May. Time being matter. Item number 5.
The instruction sought for was communicated, my lord. But unfortunately, it has not been received, my lord. Can I pray for some more time?
How much time you need?
1 week, my lord.
Let us issue notice.
Notice.
Heard Mr. B.D. Jackal. Learned Counsel for the petitioners. Miss Handboard, Standing Counsel. Who is for finance?
Finance, Mr. H. Uliha was there in the morning, your lordship.
Sir?
H. Uliha was there.
H?
H. Uliha. A. Soliha.
A. Soliha, Standing Counsel. Finance Department for Respond number 1. Ms. Anne Bodole, Land Standing Counsel. Revenue and Disaster Management Department for the respondent number 2. Mr. Anne Das.
3, 4, 5.
Land Junior Government Advocate for the respondent number 3, 4, and 5. Post of para. The petition number 1 is a company incorporated under the Companies Act 2013, which is represented by the respondent number 2, petition number 2. Pursuant to a resolution of the Board of Directors of the petition number 1 company. Resolution dated 13/3/2026. The petitioners are collectively referred to hereinafter as the petitioner for sake of convenience. Post of para. The petitioner has stated that it had entered into a memorandum of agreement, MOU, with the respondent number 6 company. On 27/7/2023. In respect of the properties outlined therein for transfer the properties by way of transfer by way of sale in respect of the properties outlined therein at a valuable sale consideration at a consideration of rupees 52 crore 51 lakh. Post of. As the lands in respect of which the MOU had entered into by the parties fall in a category of T periodic occurrence, comma, no objection for registration of any agreement of sale was necessary from the state government in the Revenue and Disaster Management Department. Full stop. It was on 5/10/2023. Comma, the state government in the Revenue and Disaster Management Department conveyed no objection for registration of agreement of sale and a connected power of attorney between the petitioner company and the respondent number 6 company, subject to the conditions mentioned therein, comma, which were required to be complied by the petitioner company. First of one of the conditions mentioned therein was to the effect that the agreement for sale and the connected power of attorney shall have a validity for a period of 1 year from the date of registration. Two of the conditions, and the suitable convenience deed shall be registered within the validity period of 1 year from the date of registration of the proposed agreement for sale and the connected power of attorney. First. Thereafter, on 14/8/2023, the agreement for sale was and the general power of attorney were registered. As those were registered prior to no objection?
The date is 16/11/23. 14/8 is the date.
Page 126?
Was 77, man. 126 is the date of purchase of the stamp paper.
Registered on?
16/11/23.
16/11/2023.
16.
By the specific power of attorney, comma, the attorney holder was given the responsibility to take deed of conveyance and the petition number 6 company was made responsible for making necessary applications toward transfer of the property in question. The petitioner has stated that as certain disputes and differences arose between the parties and due to elapse of sufficient time period. In the meantime, the petitioner company was compelled to institute a suit, title suit, title suit number 102/2025. Seeking inter alia decree that the terms and conditions of the memorandum MOU dated 17/7/2023 are binding upon the plaintiff, within bracket the petitioner company and the defendant, within bracket the defendant company, respondent number 6 company. And the defendant is obligated to perform its terms and conditions. Post of A. An application under Order 39, Rule 1 and 2. Miss case number 105/2025 was also filed by the petitioner company as the plaintiff, wherein notice wherein the court issued notice to the opposite parties on 1/12/2025 before granting temporary injunction as sought for by the plaintiff. Post para. Against the order dated 1/12/2025, passed in Midge case number 105/2025, the petitioner preferred an appeal under order 43 rule 1 within bracket R CPC, which had been registered as FAO 78/2025, post op, by an order dated 12/12/2025, comma, the appeal FAO number so and so was disposal, post of para Mr. Deca, learned counsel appearing for a petition, has submitted that during the course of hearing, the petitioner has received knowledge and had come to learn that by on 9/12/2025, comma, the respondent number 4. Respond number 3 and 4 had extended the validity period What does it mean? The validity period, not of the agreement for sale, I think. Validity period for registration.
But the order says.
Meaning, no, just because they have faulted
Yeah.
in expressing it properly,
Yes.
who would not accept that?
Yes. But
What does it indicate? That you right to enter into agreement is yours.
yes.
But for the purpose of transfer,
Yes.
this period
Yes.
of registering this agreement is extended, or what?
No, doesn't appear to be that, my lord, because otherwise, without this,
Something is missing. Actually,
no, my lord, that is why I wanted to point out that because of this, they could present the expired.
validity period of the agreement for sale and power of attorney
Very clear.
has been extended
Has been extended
by the government until further approval of the government regarding registration of the conveyance deed in respect of properties.
Further extension of the agreement.
Properties this paragraph 23 conveys it in respect of Khobong TSA Private Limited. That is respond number 6.
The garden, yes, yes. Yes.
This paragraph is somewhat properties conveys it in respect of or in favor of.
Yes, in favor of, and the garden is also called Khobong TS.
In respect of Khobong Tea Estate. Khobong, KHOBONG Tea Estate. Full stop. It is the contention of Mr. Deka that the agreement for sale was between two private parties and the terms and conditions incorporated in the agreement, which was in the nature of a private agreement, could not have been was entered into mutually. First of by the order dated, first of he has submitted that by the order dated 5/12/2023, the validity of the said agreement for sale by the on 5/10/2023, the state government had conveyed that the agreement for sale would have a validity period of 1 year from the date of registration. Subsequently, on 11/12/2024, the validity period of the agreement for sale and the power of attorney was extended for further 6 months, and subsequently on 9/12/2025, the validity of the agreement for sale and the power of attorney was again extended for another 6 months until further approval of the government regarding the registration of the conveyance deed in respect of Khobong Tea Estate. Post up. It is his contention that post up. He has pointed out that in the meantime, the conveyance deed had been registered on 1/1/2026. Post up. It is his contention that the state government could not have extended the validity period of the agreement for sale, which was entered into between two private parties and was in the nature of a private agreement, and the connected power of attorney unilaterally post up, which no such power of extension is available for extension of the validity, with no power for extension of validity is available to the state government as per the to the respond number 4. Respond number 4.
Yes.
3 and 4.
Yes.
As per the notification dated 5/12/2023, the subsequent registration of the conveyance deed is illegal and without any authority of law. Post up. Mr. Daka has submitted that with such registration of the conveyance deed on 1/1/2026, it is available for the respond number 6 to alienate the property mentioned in the conveyance deed, by way of transfer. Post up. He has submitted that the issue of authority and jurisdiction of the respond number 3 and 4 to extend the validity of the agreement for sale and power of attorney requires an adjudication at first. If no such authority and jurisdiction is found to be available to the respond number 3 and 4, then the subsequent registration of the conveyance deed would be rendered null and void. Post up. The matter would require consideration. Mr. Das, learned junior government advocate, who was asked to obtain its instruction and to produce a copy each of the government letter bearing number so and so, and no objection certificate number so and so, as reflected in the deed of conveyance dated 31/12/2025 and registered on 1/1/2026, has sought for some further time to obtain the necessary instruction and to produce the same. Post up. Let notice be issued. The notice is made returnable on so and so. As Mr. so and so has appeared and accepted notice, issuance of formal notice will say the respondents is dispensed with. The learned counsel for the petitioner shall have furnished requisite number of extra copies of the petition along with annexer to so and so within 2 working days from today. The petitioner shall take steps for service of notice upon the respond number 6 and respond number 7 by speed post. as well as the usual mode within 3 working days from today. Full stop. Having heard the learned counsel for the parties also on the interim period and finding primacy force in the submission of the learned counsel for the petition with regard to the apprehensions regarding alienation of the property mentioned in a conveyance deed dated 31/12/2025 and registered on 1/1/2026. It is ordered, in the interim that the respondent 6 shall not take any further steps but this again would require approval of the government.
Which one?
For conveying the property, again would require approval of the government.
Perhaps, but the power of attorney has also been extended.
So again, district commissioner,
Will apply on
again agreement for sale, again conveyance deed.
Because 258, it mentions given extension letter white number this. This is also very
The
important.
respondent number 3 and 4 shall not accord any approval for any agreement for sale and any conveyance deed in respect of the properties of Khobong Tea Estate as Khobong Tea Estate as mentioned in the agreement for sale dated. What is your agreement?
16/11/20.
16/11/2023. 3 annexer
8.
8 till the return date.
Annexure E, I'm sorry.
Annexer
E.
E.
On the basis of that conveyance.
Those properties,
Yes.
respondent number 3 and 4,
Yes,
respondent number 3 and 4 and respondent number 2, 3 and 4.
2, 3. Obligement.
Instead of giving a direction to a private company, it should be the state responsibility.
Supplementary list, item 50.
On the last day, because of the superintendent of police, we have not made the concern officer a party.
Heard Mr. B.D. Kumar, Learned Senior Counsel, listed by Ms. Learned Counsel for the applicant and Mr. N. Goswami, Junior Government Advocate for all
except
for the
5
opposite party number 1, 2, 4
and
1, 2, 3 and 4.
6 and 7.
Para Mr. The instant interlocutory application has been filed by the applicant. Sorry, the applicant as a read petitioner has preferred the connected read petition WPC number 2341/2026. So the instant interlocutory application is preferred by the applicant read petitioner seeking implement of the following parties: 6 and 7.
7 and 8. And 3 will be removed, my lord. Superintendent of police will be deleted.
Seeking implement of the following parties, paragraph 4 doesn't. As party respondents in the connected read petition. The applicant petitioner has further prayed for deletion of the
Number 3.
of the party respondent number 3 in the connected read petition from the area of respondents. Full stop. But having regard to the statements and developments made in the instant interlocutory application and the connected read petition, it is found that the proposed party respondents are necessary parties for adjudication of the issues raised in the connected read petition full stop. As there is no office by the name of the respondent number 3, comma, the prayer for deletion of its name from the area of respondents is allowed. Full stop. Is reasonable. Full stop. In such view of matter, the instant interlocutory application stands allowed. The learned counsel for the then everything will be changed.
Change.
Oh.
Learned friend will
No,
just
before
call-
before it a parato deletion of name to agotobo. Then deletion of name যদি হয় deletion of name যদি হয়
He will be deleted, then sequence will change.
Sequence will change. She will be deleted. 4 to 3.
And 4, 5, 6, 7 will be now
5,
3, 4, 5, 6, 7.
6. Okay. As the following parties, following parties, as party respondent 7 and party respondent by 8 respectively. Deletion to আগত করে দিল তাই বললে 8টা 6টা yes. The learned counsel for the applicant, learned counsel for the applicant petitioner shall file an amended cause title with the amended cause title before the registry by tomorrow.
Yes.
By tomorrow, first of all, submission of the amended cause title, comma, the registry to cause necessary correction in the cause title of the writ petition as well as in the CIS. First of para. Next. Okay, heard Mr. B.D. Cole, and senior counsel registered by Ms. So-and-so, learned counsel for the writ petitioner, and Mr. N. Goswami, learned senior government advocate for the respondent number 1, 2,
3, 4.
Not okay. 3, 8. No, before that, leak out. 1, 2, 3,
5 and 6, 7, 8.
3,
3 will,
3, 4, 4, 5,
4 will be 3 now.
6, 7,
3, 5,
1,
6,
2, 3,
then 5,
3, 5,
6,
6,
and 7.
7 and 8.
Sorry. Yes.
As per the amended cause title,
For
which
respondent
has been
number,
directed to be filed by the petitioner by tomorrow. Full stop.
for respondent number 4, we'll take usual notice as well as by task.
No, let us have, we are not issuing notice.
Let him file a report.
Your grievance is regarding
Well, other than 156.
respond number 8. Let us have first an opinion. Okay. The cause of grievance of the petition. Is the officer in charge, Bokhisto police station, did not register an FIR lodged by the petitioner on
9, just a minute. Date कौन? नहीं वो लास्ट वाला जो कमिश्नर को एफिडेविट दिया है. Just a minute. आप लोग 24/4/2026.
On 24/4/2026, despite the fact that the FIR indicated commission of cognizable offenses. Full stop. agree by such non-registration, the petitioner submitted a complaint or representation before the respondent number 8 on 19/4/2026 within bracket page number 129-132, which was duly received and acknowledged under seal and signature on 19/4/2026. Full stop. It is a case of the petitioner that despite receipt of such representation on 19/4/2026, no action as required.
And my lord, further the respondent number 4, who is the sub-inspector of the concerned police station, was present at the place of occurrence while I was illegally disposed.
No action as required under the provisions of Bharatiya Nyaya Nagorik Surakha 2023 has been taken by the respondent number 8 period. It is the petitioner has projected that it was in the presence of the respondent number 4 and the petition was disposed from his plot of land on which date?
On this, on 19/4/2026.
19/4/2026. Post of para. Mr. Goswami shall obtain instruction from the respondent number 8 as to what action has been taken on the representation dated 19/4/2026. Post by the respondent number 8. Release the case on Friday. What's it? Friday?
Let it be on Monday, my lord. Friday I will be out of station.
Okay. File your amended cost title. Otherwise, my order will be defective.
We'll file it by tomorrow. He'll start some copy. Yes, with all.
Miss so-and-so learned constable petitioner shall supply a copy of the writ petition along with annexer with the amended cost title to Mr. Goswami by tomorrow, so as to enable him to obtain instruction in the matter. Release the case on Monday.
Deeply obliged, sir.
Item 51 for impingement of party. Item 51.
There is no representation on behalf of the petitioner to join call. This is the case on Friday.
Friday. 15. Daily list for admission. Item number 23.
Mayor Lordship. Lordship may peruse the order dated 25/2/26.
25/2/26.
Lordship, para 8, 9, and 10, Lordship, the order.
Liberty is given to respondent number 4 and 5 to implement the respondent number 3 in which proceeding?
Before the labor court. Lord.
Before the labor court,
Yes.
not in the instant proceeding. It is already there.
I am already there for respondent number 3, Lordship. Lordship, the direction was twofold, Lordship.
Okay, for respondent number 4 and 5, there are two proceedings.
Proceeding, Lordship.
Case number 1 and case number 2.
Lordship.
Yes.
Lordship, the direction was twofold. One was to implead respondent number 3 in the industrial tribunal proceedings, my lord, labor code. The second was to.
Who represents respondent number 4 and 5?
Respondent number 4 and 5, Lordship, I am on behalf of Abjad Majumdar, Lordship. He is
Okay. Okay.
Persuade-
Liberty was granted to respondent number
Yes,
4 and
Lordship.
5 to implement respondent number 3 herein as
In the
it is in the
labor code.
proceeding.
The
Yes.
second was to.
Resolution plan.
Yeah, Lordship, to the respondent number 3. So they have already filed their claim before the RP. That is the RP for respondent number 3, Lordship, as the respondent number 3 is already into liquidation. So, Lordship, the RP of respondent number 3 is taking the necessary steps.
Which is in liquidation.
Respondent number 3, Lordship.
And who is taking over?
That is some different company proceedings going before the NCLT, not in relation to the present proceeding.
1 minute. 4 and 5 were employees of petitioner.
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 What happened, Lordship? They were the employee of the petitioner. During the pendency of the labor court proceeding, business transfer agreement has been executed between me and the respondent number 3. And by virtue of that business transfer agreement, all the liability has been taken over by respondent number 3. That has been reflected in the order.
And respondent number 4 and 5 were terminated earlier than the business transfer agreement.
No, they were terminated.
Yes, yes.
2 years before the business transfer.
Yes,
Yes,
but by virtue of the labor code order, because their termination order was
illegal.
Deemed illegal. So by virtue of that, they are deemed to be in the service of the petitioner on the date of business transfer agreement.
Yes,
Meaning thereby their services would be also included in the role of the petitioner, respondent number three, right?
Lordship.
And accordingly, the entitlement are required to be decided.
Decided before in the
Yes.
proceedings under section 33, Lordship.
And so resolution professional was asked to include that
Lordship, the
into account.
respondent number 4 and 5 was already submitted.
And in the meantime, that has been again transferred or what?
Lordship, the respondent number RP.
3.
Lordship. No, Lordship, the RP has already filed the resolution plan before the NCLT. So now they have filed their claims before the RP. So the RP is in process of giving the reply to the respondent number 4 and 5 that they have to approach the NCLT in respect of delay condonation of their claims, because this direction was given in the month of February, Lordship, and they had posted their claims on 20th of April. So now Lordship may dispose of the instant petition, as the respondent number 4 and 5 has already impleaded us in the labor court before the section 33 proceeding, though we have not received the notice, Lordship, and they have already filed their claims before us. So this petition may be disposed of.
They have been impleaded. Sorry, respondent number 3 has been impleaded.
Lordship, as per the
By which order? Any order? Date?
Actually, Lordship, I am appearing on behalf of
FZ Mazumdar. He has some personal difficulty, Lordship. He has told that we have been impleaded, but notice has not been received, Lordship. So Lordship may dispose of this writ petition in terms
And
of
second one?
the second one. They have filed their Lordship. They have filed their claims before us. So now what is the difficulty is, Lordship, that the resolution plan has already been filed before the NCLT after the same was approved by the Committee of Creditors, Lordship. So now the respondent number 4 and 5 has to approach the NCLT along with a delay condonation petition, and the NCLT may decide in the claims of respondent number 4 and 5. Otherwise, they have a valid award of the labor code.
Now, paragraph 9.
Lordship. Lordship, the direction
is made to the resolution professional
Lordship.
appointed by NCLT to take into consideration the claims of the respondent number 4 and 5 while preparation of the resolution plan.
Lordship.
So this is directly to the
respondent number
resolution professional, not to the respondent number 4 and 5.
But the Lordship, the claims has to be filed by because there was the claims of
it goes to indicate
Lordship.
It is responsibility is cast upon you,
Lordship,
to amend the resolution plan.
Lordship, they have
not one delay condonation.
No, Lordship,
I don't think it is resolution that they have to file an application for condonation
Lordship,
of
this
delay.
direction was given in the month of February, Lordship.
Whatever,
they had
direction is to you.
Lordship, but
you have to file a condonation application.
But the claims have to come to the resolution professional.
They have filed it before you, and this direction is there. There is don't read something into the order which is not there. You seek a modification otherwise.
Lordship.
How can it be? Para 9 is clear.
That we have
this code directs the interim resolution professional so appointed by the NCLT to take into consideration the claims of the respondent number 4 and 5 while preparation of the resolution plan.
Yes.
Right? There is nothing to be done by respondent number 4 and 5. It is you who has to do it everything. Now, why you are making this submission that they have to file an application for condonation of the delay? They are already running from pillar to post.
Lordship, but in this proceedings, the claim of respondent.
Now, this is a High Court order.
Lordship.
Don't read something which is not there.
Lordship, I will.
They may have to revisit the resolution plan.
You have to amend the resolution plan to include the claim of respondent number 4 and 5.
I will instruct my client.
They do not have to do this thing, go to the NCLT and file an application for this thing, that thing.
Lordship,
that is not the direction.
Lordship, I'll instruct my clients in this regard.
You instruct your.
Lordship, I will.
And don't think yourself bigger than NCLT or High Court.
No, Lordship,
that seems to be a impression on the resolution profession.
Lordship.
Don't think yourself bigger than the order of the High Court.
Lordship, I'll instruct. Yes, your Lord.
Come up with your amended resolution plan, make an, seek an amendment to the resolution plan.
I'll instruct my clerk.
Don't ask them to file a condonation application.
Lordship, I'll do.
Heard Mr. H. Chakravarti, learned counsel for the petition. Mr. S.S. Roy, learned junior member for the respondent number 1. Mr. M. Sahewala, learned counsel for the respondent number 3.
3, Lordship.
Who, Mr. Sahewala, who represents the interim resolution professional, come up for the respondent number 3. And Mr. FZ Mazumdar, learned counsel for the respondent number 4 and 5. Post up. The learned counsel for the parties have referred to the order dated 25 to 2026, which contained 2 directions. Post up. The first of the direction was to the respondent number 4 and 5 to implement the respondent number 3 in the proceedings of case number 1/2022 and case number 2 of 2022. Presently pending before the Labor Court. Which are proceedings initiated in terms of section 33C within bracket 2 of the Industrial Disputes Act 1947. Post stop. Para, Mr. Mazumdar, learned counsel preparing for the respondent number 4 and 5, has submitted that subsequent to 25 to 2000, in reference to the order dated 25 to 2026, the respondent number 4 and 5 had filed application seeking implement of the respondent number 3.
Notice also sent, issued by the labor.
In case number 1/2022 and case number 2/2022. Post of the he has further submitted that the learned Labor Court has allowed
Yes.
has allowed
Allowed.
the applications for implement by an order dated
Lordship, this order.
has already allowed the applications for implement and directed issuance of notice to the respondent number 3. Accordingly, respondent number 3, the respondent 4 and 5 have taken steps for service of notice upon the newly implemented respondent number 3. Para. The court, by order dated 25 to 2026, also directed the interim resolution professional appointed by the National Company Law Tribunal, Mumbai, to take into consideration the claims of the respondent number 4 and 5 while preparation of the resolution plan. Post up. Mr. Sahewala, learned counsel appearing for the respondent number 3 and representing the interim resolution professional, has submitted that a resolution plan has already been submitted. Post up. It is, and therefore, the respondent number 4 and 5 are required to file appropriate application before the National Company Law Tribunal, Mumbai, for consideration of their claims. Post up. From the order dated 25 to 2026, it clearly it transpires that it is the interim resolution professional who has to take necessary steps for consideration of the claims of the respondent number 4 and 5 in the resolution plan, and if required, by an amendment, or modification of the resolution plan. Post of para, Mr. Saivela, learned counsel appearing for the respondent, appearing for the interim resolution professional. Has got how much time you need?
3 weeks.
2 weeks time to obtain further instruction in the matter. 3 weeks time. Release the case on source.
5/6, 5th June.
Lordship, I humbly apologize. My item was listed right before this item on implement of orders, Your Lordship. I was on Lakes Estate.
Friday, I have directed. Friday.
Item 24.
In this case, Lordship, today just now I have received the records. Let it be on Friday, Lordship. Just now I have received.
H.R. Ahmed, learned constable of petitioner is present on the request of Mr. S.S. Roy, learned junior government Assam, who has received the record is relevant records. List the case on Friday.
Obliged. Item number 25.
May I please, Your Lordship? Lordship, in this matter, we need some accommodation, Lordship, as learned counsel DC Das is not well, Lordship.
Is this?
So kindly,
On the request of Miss
Nanda.
Nanda, learned counsel appearing for Mr. B.C. Das, learned senior counsel for the petition. The prayer of adjournment is allowed on the ground that Mr. Das is indisposed. Release the case as sought for after 2 weeks on a date fixed by the office.
Bless, Lordship.
Items 26 to 28.
Yes, it can be released. Yes.
Lordship, in item number 27, they had to file a reply. They're yet to file the reply.
We had, with regard to item number 27, we have already
7
filed
to-
the affidavit in opposition.
27 to do. What are the 3 matters? Why 3?
Lordship, 2 matters, item number 26 and 28 pertains to the same proceeding under the Bakijai department. RERA had passed an order asking them to proceed as per the Bengal Recovery Act and recover the sum of money. They are yet to recover. It's been 4 years. So we have filed this writ petition for the inaction and arbitrary decisions and proceedings. Writ petition number 28 has been filed because during the pendency of item number 26, Bakijai office has passed one more order whereby they are releasing directors from their liability. So a fresh cause of action arose. That is why we had filed one more writ petition.
Who is respondent number 7? Is the defaulter according to you?
Yes.
So you are supposed to file a counter affidavit
Lordship,
in item number 27.
In item number 27, we have filed the affidavit in opposition. We have filed against the reply. We are going to file the counter affidavit reply. So Lordship, we are seeking.
Here, legal. Now you say that you do not want to file any counter.
No, we are going to file. We are seeking a 1 week time, Lordship, to file the affidavit. Because the
You have not filed any affidavit till date.
no,
Or
we have
you
filed the
filed?
affidavit in opposition.
Yes.
Yes.
Now this affidavit is for what purpose?
They have in their reply they have made some allegations which we are going to file in the form of affidavit by way of replying that.
Some new things or what?
Lordship, we had just merely given reply, para-wise reply to their objection, written objection. So now they are seeking time to file rejoinder since past 2 dates. counter affidavit.
Lordship, the answering deponent, he was out of station, so he recently reached home. So we are seeking 1 week time so that we can already.
So after making default, he is out of station.
Lordship,
Huh?
we are going to file our reply in the sense that they are making us allegation of double sale. They are making an allegation of double sales, which we are to put in the form of affidavit.
Making allegation of?
Double sale. Double sale.
What is this term?
In the sense that Lordship here, they have made the petitioner has alleged that we are, on our part, they have executed 2 sale deeds. Which in
Double sale.
Double sale.
Yes, Mr. Talukdar, what Bakijai officer is doing?
The report was called from the circle officer, whether he has got any other property in his circle. The report has come that he has no other property. Last order is 27 to.
Now let him declare respond number 7 that I don't have any property.
Lordship, I think, sir, is in item number 26, no assets have been found. Now item number 27.
27.
All take.
No, he has filed an affidavit in opposition. Right.
Lordship, there is some confusion in item
No.
number 26.
No, ultimately the question is whether he has any property or not, immovable property or not, or movable property in the form of anything tangible, which can be freezed or which can be confiscated or something like that. Whether he has disclosed anything in the affidavit.
No, Lordship, actually, he has filed in a personal capacity of a director, whereby he's saying that I had already resigned from a directorship.
Oh, that's number 7.
Respondent number 7, the director, that we had already resigned from the builder company. So now we are no longer associated with the company. So we are not liable, personally liable to repay.
After the order, RERA.
After the order.
That was not the...
Exactly, Lordship. Item number 28 also we have filed because the resignation year is 2024. After the order was passed from RERA and the proceeding is pending. After that, you cannot discharge any director. Since Bakijai has discharged...
Then let us attach all the public properties of respondent number 7.
Let us find out.
Disclose your properties then. If you are trying to subterfuge the entire process, then I'll direct you to file an affidavit regarding your properties, movable and immovable. We'll take over the proceedings from Bakijai officer.
Lordship, before coming.
This is not the way to cheat the people and thereafter try to take advantage of the process. Loopholes in the process. What is this after a resignation from the company? You don't have any liability. That is in the different context. Here is an order. I think it is preceded by an order of RERA.
Yeah.
Don't try to compare this proceeding with proceeding of NIAC. NIAC starts with an issuance of notice, dishonour of check. Prior to that, if the director resigns from a registered incorporated company, he may not have any liability. But here is a case, the resignation is after the order, so liability persists. That is not a plea, absolutely. So, has he disclosed anything about his own?
In fact,
let us have his affidavit, then we'll go up. We'll try to go after him. Let us have this affidavit. Now, what is your report?
The report says there is no other.
If there is any that have been already,
he must have.
He must have cleared it.
Yes.
How much is the?
In one matter, it's the 71 lakhs, in the other, it's 30 lakhs.
30 lakhs.
Yes, 70.
Is there any other person like you?
Many, Lordship.
Many.
In fact, I have
Many.
been fighting, yes. There are many clients, after the RERA order is passed, 2 years has elapsed, Bakijai is not even issuing notice on the respondents. And to this effect, multiple writ petition has been filed now.
Respondent number 7 is Babul Chaudhary.
Yes.
Mr. Taludar. If I am not wrong,
Yes, Lordship.
if I am not wrong, he is Babul Chaudhary.
Yes.
What is this Haider Alam Azad?
Number 26. Writ petition number, there are two parties. Two different subject matters, two parties. One is Babul Chaudhary, in which 71 lakh is due. The other is Haider Ali, although the petitioner is the same. In Haider Ali, you have
Tell
given
me,
what?
just a minute, just understand. Who is the RERA order? RERA order.
Page number 24. In writ petition number 5817.
I am holding 27.
Yeah.
Page 24.
Yes, page 24. And in page
So
number.
it is a private limited company.
It is a private limited company.
Incorporated under the Company.
Companies Act.
Now, against whom the Bakijai proceedings have been initiated?
Respondent number 6 is the builder company, that is Me Infrastructure.
Respondent number. Some amended cost title.
Yes, Lordship.
Okay, respondent number 6.
Yes.
And it has only one director.
It has 4 directors. And Babul Chaudhary is one of the directors. They have filed an IA because in Bakijai proceedings, Babul Chaudhary's valuation of his assets were valued. So now they had come asking for impleadment, which was allowed. They are saying that we have already resigned, so our property should not be auctioned. That is why, and they have quoted one of the orders of Bakijai, whereby one more director named Dulu Ahmed in writ petition number 28. He was released because his resignation is of year 2024. They are saying since he's been released, we are also to be released because we have also resigned.
Okay. Okay, we'll leave that issue. But that order by where he has made the prayer? Before Bakijai or officer?
Before Bakijai officer, they had filed.
That the one Mr. Dulu Ahmed has been released, so I may be released.
Yes. And that was not entertained. That is why in my writ petition, they had filed an IA for impleadment, saying that they are a necessary party. So his property should not be attached and auctioned and to be heard.
Okay, Mr. You file your affidavit.
Yes, we will file the affidavit. At the same
What kind of affidavit you want to track?
we will file against the reply, Lordship, because
In a writ petition, that is not permissible.
Lordship.
Affidavit, writ petition, counter, rejoinder. So what allegation, with what specific, which specific environment is to be traversed? Please tell me.
Lordship. Lordship, here
Page.
No, I'm not reading the any pages in the affidavit of the said, but I'm just saying on my personal note, Lordship, because execution of the deeds, they are alleging the execution of the deeds in my personal capacity, but it is all false and frivolous. Lordship, on the
1 minute. False and frivolous is a very standard dialogue. Affidavit in opposition, you have filed. Or
yes,
who has filed? You have filed. Running more than 100 pages. Running more than 100 pages,
Yes.
your affidavit in opposition.
Yes, Lordship.
Right? They have filed an affidavit in reply. Now, which specific part is newly introduced and which requires a reply? Because for filing such an affidavit, a leave is required. And court is to be satisfied that such leave is to be granted. Yes. Which one? will not allow you to file another 100-page additional affidavit.
No, Lordship, we will not.
Tell me which specific part.
Lordship, here at page 309 of the
309.
309 of the affidavit in reply by the petitioner.
309. Schedule B. Schedule B, Schedule
Yes.
C, Schedule D.
Yes, Lordship.
It perhaps is a registered document.
Yes, Lordship.
Registered document, it bears signatures. It bears signatures. It is part of some document.
Lord,
It is now, it is,
affidavit in reply, we have annexed certain agreements. After he had made this particular director, Babul Chaudhary, he had sold us the property and subsequently had sold to someone else also. So we have attached those documents whereby we are saying this particular director was the mastermind. He knew that at the time of making sales to someone else, he knew that he had executed an agreement with us. So we have bought that on
page 296 is a deed of agreement.
Yes.
Now, where his name appears?
290.
Okay, represented by Babul Chaudhary. If you want to say this Babul Chaudhary is not you, then okay, I'll permit you.
Lordship.
If this Babul Chaudhary, whose name appears at page 296, or the first page of the deed of agreement, registered deed of agreement, that you are not the one who had executed it, if you are ready to submit that on oath, will allow you that this signature is not yours at page 312, then we'll allow the petitioner to file an FIR to identify the real Babul Chaudhary. The real Babul Chaudhary. What is the purpose of your additional affidavit in opposition?
But Lordship, here.
So tell me, what is the main purpose?
Lordship, I have not executed any deed in my personal capacity, Lordship.
That is,
And the
that is
existing
clear.
and the Lordship existing.
No,
Lordship
that
has
is clear.
undertaken
That is
process.
not to be read. That is to be read into from page 296. Ma Infrastructure Private Limited, a private limited company represented by one of its director, Babul Chaudhary. It is clear that it is not in individual capacity. What more is required? He has signed, not in his individual capacity, right? In his official capacity. Official capacity. Babul Chaudhary, page 312. So what purpose you need? Please tell
Lordship,
me.
in that case, Lordship, allow us.
Tell me, I'll allow you, but show me the reason.
So,
That clarification is not required.
Lordship, I'm just asking, sir, Lordship, allow us to give at least one more week to final reply in the sense that because my senior will highlight the points very clearly, Lordship.
Highlight, I'll allow you. Then after highlighting,
Because
only I'll allow you to file affidavit in opposition. I'll not allow you to file affidavit, counter affidavit, one more. This is not the way to increase the weight of the brief.
Lordship, in that
You
case,
satisfy us. I'll point out the law regarding filing of more pleadings after affidavit in reply.
Lordship, in that case, let my senior appear.
Who is your senior?
An alam. An alam.
An alam. And let him come prepared.
Lordship.
Yes. Miss
P. Gupta.
P. Gupta. For the petitioners in all?
Yes, Lordship.
Learned counsel for the petitioner in item 27. Mr. B.J. Taludar, learned senior counsel extended by Mr. P.K. Medil, learned counsel for the respondent number 1, 2, 3, 4. And sir,
S.A. Bhatia,
S.A. Bhatia, learned counsel for the respond number
7.
7.
7. In five,
Who is
item
7?
number 27.
No, on 27. Item number 27. I am concentrating on 27.
Yes, Lord.
There is no response number 7.
Lord.
5 is
We have amended the cost title also. There is a,
yes, madam, please tell us. Amended cost title. Who is response number?
They were directed to amend the cost title after
and
the
we have already
restatement was
submitted
allowed.
lordship.
Which page? So many cost titles here. Okay.
Yes, lordship.
Who is for RERA? Anybody from RERA? And you don't represent response number 6?
No, lordship.
Only response number 7. Okay. Where is your resignation? Mr. Gupta, where is his resignation? Had it been accepted?
Exactly, they are on
Had
the
it been
last date.
His
just
DIN has been removed.
They have not submitted, they have just given their resolution. But whether it was accepted, whether they had submitted it, nothing on record.
Where is that? State.
Page number 127, Lordship will find their resignation in their affidavit in opposition. Yeah.
Where is that provision in the Companies Act 2013 about resignation of director? Please bring out those provisions.
Yes, Lordship.
For response number 7. Mr. Bhatia, learned counsel for the response number 7 has submitted that the response number 7 has already resigned from the directorship, board of directors, as director in the board of directors of response number 6, pursuant to a resolution dated 18/2/2019. Madam, correct or not?
Yes.
18/2/2019. Full stop. The response number 7 has, however, not annexed any document registered in the designated portal of the Ministry of Corporate Affairs, wherefrom it can be noticed that the response number 7 had submitted, response number 7's resignation was registered prior to the order dated 19/2/2022 passed by the Real Estate Regulatory Authority, Assam, in case number Assam/RERA/2017/267. Post up. The Mr. Bhatia has sought listing of the case after a week in order to obtain further instruction in the matter. List the case on so and so along with 26 and 27 on so and so.
Lordship, in item number 28, as per the office note, service on respondent number 6 is not complete. So I may be permitted to take fresh steps.
Okay. 28. P. Gupta, petitioner. Mr. Aforesaid, Revenue and Disaster Management Department, for the response number 1. Mr. B.J. Talukdar, Senior Counsel, arrested by Mr. P.K. Medhi, Learned Counsel, for the response number 224. Peruse the office note dated 6/5/2026. First stop. Ms. Gupta, learned counsel for the petitioner, has submitted that the petitioner be allowed to take first steps upon the response number 6 at his correct and proper address. The prayer is allowed, the petitioner shall take first steps for service of notice upon the respondent number 6 by way of speed post at its correct and proper address within 3 working days from today. বাকিখিনি আগৰটো নিচিনা 7 দিনৰ পিছত আহিব আৰু is the case on cases on so and so এইটো 27 ত দিব item number 27 ত লিখিব list the case with so and so on so and so after 7 days.
7 days.
Let Mr. Alam come.
8 দিনৰ পিছত
লৈ ল'ব item number 27 ত লিখিব list the case on so and so with so and so. বাকিটা অৰ্ডাৰ থাকিব আইটেম নম্বৰ 28 থাকিব 26 কোনো অৰ্ডাৰ নালাগে আৰু নিজে নিজে আহি যাব না
10 June. Step
no after 7 days item
25th.
28 বেলেগ এটা release the case after 4 weeks.
The
We'll examine first 27.
before 25th of this month, Lordship, because I have
If he is not there, he will be there.
Lordship, also before 25th of this month, Lordship, we are having problem in that matter.
Court will be having problem according to our calendar.
Lordship,
Next.
there is some difficulty on my part also on 25th, if 26th or
Let him tell the date first. Don't try to express your difficulties without knowing the date.
22nd.
Not surprised.
Organized.
Item number 30.
Yes, please.
My lord, in this matter, Lordship, petitioner is aggrieved by an order.
Board of Revenue.
Board of Revenue has passed order in favor of the petitioner.
Restoration of patta.
Restoration of patta.
Where is that order?
That order, your Lordship will find it at page 18, Lordship.
Who was the appellant there? Petitioner.
Yes, Lordship. Petitioner was the
Rohan.
appellant, Lordship.
Okay. Appeal against the Eastern Revenue Officer Fulani, however, patta has been cancelled. An order dated so and so has been passed by the Joint Secretary wherein the land has been settled with an institution represented by the private respondents. Patta has been cancelled. Okay. Against that, you have preferred the appeal.
Preferred the appeal, Lordship.
And where is the appeal is allowed, set aside,
Set the order passed by the-
corrected. Joint Secretary has passed his order, pending the so and so. Based on the order where subsequent orders are set aside. Yes.
May it please say Lordship.
Yes. Thereafter,
Therefore, Lordship, one self-style Lordship, Vigilance Society, Lordship, they approached before the Honorable Gauhati High Court, Lordship. And the Honorable High Court has passed the order, Lordship, setting aside the Lordship, order passed by the Revenue.
against that order.
Against that Revenue order, Lordship. Against that Revenue order, Lordship.
He was a non-party in the before Board of Revenue. He was not a party.
He was party, Lordship.
It was a party.
He was responded in that Revenue Board matter. Lordship.
It was dismissed.
Yes, it was Revenue Board order, it was allowed, Lordship, because I was the appellant.
No,
in
writ
that
petition
matter.
was dismissed.
Yes, my lord. Then, Lordship, writ petition was dismissed, Lordship. And my lord, that society approached before the Honorable High Court, Lordship, challenging the Revenue Board order, Lordship. And
that
the
has
writ
been
petition was
dismissed.
Dismissed, Lordship. And that order, your Lordship will find.
Page.
Please, Lordship.
26.
Yes, madam. Yes, page 26, Lordship. Para 4, Lordship. Para 4, Lordship.
Then what happened? That patta has not been restored.
Restored. Till date, Lordship, the patta has not been restored.
Yes, madam.
May it please, Lordship, we have already filed our affidavit in this matter, Lordship, and by order dated 6/3/2026, we were asked to place the decision taken by the executive member, Lordship. Now we are praying for 4 weeks' time, Lordship, to bring that.
No. No, why this order has been passed on 3? On 6/3/2026? What is the reason for passing this order by this court?
Lordship, in our affidavit, paragraph 9, Lordship.
Paragraph 9?
Yes, page 41 of our affidavit.
Madam, come to page 19. Now, second paragraph.
Lordship.
Land was mutated in the name of the appellant. A Kacha Patta was issued on 11/2/2008.
Lordship.
Thereafter, a Kepi Patta was issued in his favor and the Jamabandi was corrected. Right?
Yes.
Now come to page 18. This is an appeal against an order dated 24/9/2009 passed by the Assistant Revenue Officer Fulani,
Yeah,
whereby the appellant's patta has been cancelled.
Lordship.
And an order dated so-and-so passed by the Joint Secretary so-and-so wherein the said land has been settled with an institution represented by the private respondents. Now, by the revenue appeal, the Assam Board of Revenue has cancelled this 24/9/2009.
Yes.
Yes.
Right, set aside. As a result, all consequential order has been set aside. So, meaning thereby patta has been restored to him. Now, why this all this exercise now?
Lordship, in our affidavit, paragraph 8, Lordship.
You have taken me to paragraph 9 already.
No,
There is nothing.
Before that, Lordship, 8, the brief facts of the case, Lordship. That measuring 5 bigha 2 katha 7 lecha covered by dock number 228 so and so village Tiniali Moza Longfar under Puloni Revenue Circle was originally recorded in the name of Kamalapati Sharma, son of Devilal. After his death in the year 2008, the said land was mutated on 22/2/2007 in the name of Shri Bijay Sharma, son of Kamalapati Sharma, and Srimati Uma Devi, wife of Kamalapati Sharma. It appears from the chitta that subsequently on 11/2/2022, the name of Shri Suraj Chauhan, son of Mahadev, was recorded in place of Shri Bijay Sharma. And
Purported sale. Now you have said now purported sale. A new thing has been introduced.
Lord.
Now come to the order again of the Revenue Board. Para 2, page 19. Page 19. A registered sale deed on 20/01/2008. Now what is this purported sale now? Question of Rule 26 will not come here. The commissioner has the power to cancel patta. That patta was never challenged by anybody.
Yeah.
And the commissioner under Rule 26 has the power to cancel patta. Now here, registered sale deed is already there. Thereafter, kacha patta. Thereafter, periodic patta. And that periodic patta was cancelled by an unauthorized official. And thereafter, certain more transactions happen. But if that order of the Assistant Revenue Officer was set aside due to lack of jurisdiction.
Yes.
If lack of jurisdiction, then all consequent actions are bad. When the foundation falls, the structure falls. Meaning thereby the patta is restored. If no action is taken by anybody for cancellation of the patta, why all these exercise?
Lordship.
Why is Mr. Chutia?
Lordship, I'll place in the other court. I'll inform you.
In the instance of some private parties, you are trying to unsettle everything. Why 26 is required? Why he is making submission that under Rule 26 of the settlement rules, something is required by executive member? Why you are trying to
because
unsettle a position which is already settled in 2008?
there's some issue, Lordship. I'll call my senior Lordship.
Do you have the registered sale deed or not?
My lord, yes, my lord. Registered sale deed. We do have.
Mr.
D. Bhuya, my lord.
D. Bhuya, Learned Counsel for the petition is present on the request of Ms. S. Camprai, Learned Counsel, Standing Counsel, KASC, release the case on next Wednesday.
20.
Be clear
Lordship.
whether Rule 26 comes into picture.
Lordship.
If so, in what manner? You are trying to make a mountain out of a molehill just because you are Karbi Anglong Autonomous Council. And situation is very fluid in as regards the land system. So you are trying to take this position, that position every time without framing any kind of law. Supreme Court has said you have no power in 1960s itself. Please come prepared, madam.
31.
Deep level.
Your Lordship, here petitioners has.
Yes, Mr.
My lord, here the report has been received from the deputy commissioner. And the office of the CM, my lord, they have played for some time, my lord, to consider it the same and to pay the amount, my lord, if at all
Sanction.
eligible.
Okay.
It's an amount of rupees 2.5 lakhs to the widow of the deceased.
Council for the petition is present. Okay, new government has sworn in, so. it
Oh,
will
my
be-
lord, yes. Let it be after 4 weeks, my lord. In the meantime, we'll come up with something.
Mr. Gogoi learned additional advocate general appearing for the state respondent has submitted that you'd obtain instruction as regards sanction, grant of sanction for disbursement of the ex gratia amount of rupees 2.5 lakh in favor of the petitioner, with respect to which the petitioner has claimed in connection which the petitioner has made the claim for the death of her
Husband.
in COVID-19 pandemic.
My lord.
As sought for by Mr. Google is the case on so.
1206. My lord. Obliged.
I am the.
Item 32.
Ship has directed me to obtain instructions, Your Lordship. I received. Lordship may peruse the last page. The person's name is given, Your Lordship, who is the current commissioner. The format is given, Your Lordship, how to apply.
So second appellate authority is a commission
Commission, Your Lordship.
and it is manned by Chief Commissioner who is Sujoy Lal Hausen, IPS retired. I
No,
think
Your
he is.
Lordship. Ranjan Kumar Chakraborty.
No, Chief Commissioner.
Yes, Your Lordship. Chief Commissioner.
He was, I think, ex-DGP of Madhya Pradesh.
Yes, Your Lordship.
In person, okay, he resigned.
Yes, Your Lordship. The present is Ranjan Kumar Chakraborty.
And according to your instruction, it is second appellate authority is the commission.
Commission, Your Lordship.
So this remedy is available to him.
Yes, Your Lordship.
Okay, any time limit?
60 days, Your Lordship.
But okay, 60 days. Right to Public Service Commission.
Lordship may come.
Come to which page?
Yes, Your Lordship.
Now,
Second appellate, Your Lordship, the third page, Your Lordship. 1, 2, 3,
page?
4. Fourth page, Your Lordship. Stipulated time for second appellate authority. 60. 1, 2, 3. The fourth page, Your Lordship.
So, Parasan may condone to delay, to condone delay. Hey, Right to Public Services Act. So, নতুন আছিল এখনতে আছে
Amendment, Your Lordship, it is
amendment.
provided. Yes, the
Which amendment?
2019 amendment, Your Lordship.
2019.
Yes, Your Lordship.
This
In section 8, Your Lordship,
2009.
page number 4.
2009.
Okay.
19.
0.5, Your Lordship, 4 and 5.
2019.
Yes, 2019.
What was it? 2019?
Appeal and second appeal, the heading, Your Lordship. Section 8.
No, I'm not getting it.
Amendment is of 2000.
Oh, এক্ষণে বিষয় গেছো 19 খন নাই নেকি ইয়াতে 19 খন থাকিব লাগে
Have the soft copy, Your Lordship.
অ 19 খন দিয়কচোন তাতে আছে বুলি কৈছো ন তেওঁৰ তাত আছে
Section 8 is original.
No, section 8 or point 4 and 5.
You said 19. Oh, okay, it is there.
It's there, Your Lordship.
আছে এখন 19 এখন 19 এখন 19 section
8.
8
Appeal and second appeal, Your Lordship. Heading is there.
appeal and second appeal.
Point 4 and 5.
Section 8D.
8.
Section 8.
No, I've seen it.
My lord, in this book is it is inserted.
Okay, you will get a book.
নতুন তো আছে আপনার নতুন তো নাই
Appeal.
Lordship, point 4 and point 5. Subsection 4 and subsection 5. Also in the instruction bunch, Your Lordship, page number 4 may be perused, Your Lordship.
Because the limitation period is there. That is
Yes.
what I am examining.
Yes, Your Lordship.
The order was on which date?
My lord, it is rejected 2/12/2025. And appeal filed on 6/1/2026. Within time.
Where is that order? Appellate order?
Appellate order, my lord, it is just auto closed, page 30, annex 7, my lord. In the box bottom.
13 and 31.
Appeal submit auto.
32 বেলে গেছে
So appeal has been closed on 2/12/2025.
My lord.
To page number to billing deals.
Maybe wrong. Confidentially 28 assessment is corrected.
নোটুট কারেক্ট করা নাই Not satisfied with the raise a grievance, submit new appeal.
Miss, this is 8 A.
Lordship, if Sabone.
Phone. Nasabi na. Phone আছে। Phone আছে নাচাব না phone। মোবাইলত আছে চাব জানো? মই দিয়া মেইল কৰি দিম।
এইটো নাম্বাৰ পৰা
So commission is the second appellate authority. Okay. Let us pass it order. Heard Mr. Kiyu Amir, learned counsel for the petition. Ms. Ann Bordole, learned standing counsel, Revenue Department for the respondent number 1. And Mr. J. Hendrick, learned junior government advocate for Assam for the respondent number 2 and 3. Full stop. Para. The case of the petitioner is that, in brief, is that she purchased a plot of land measuring 2 bighas, 4 kathas, 13 lessas, comma, covered by dark number. If is it to do it? No, I can't. Dark number 485 and Roman N 486 and KP Patra number 136, comma, situated Revenue Village, Khoirabari, Mauja, Govardhana, Bornogor Revenue Circle, District Barpeta. Subject plot for short, with a Assam type house standing thereon on payment of consideration from the erstwhile owner. And the registered sale deed and the sale deed was registered on
17/11/2022.
17/11/2022 in the office of the sub-registrar
Shorbhog.
Post op. After registration, the petitioner has asserted that after registration of the sale deed, she was handed over possession of the subject plot by the erstwhile owner. Post op. After registration of the sale deed by its serial number 957 dated, by the registered sale deed number 848, the petitioner applied for mutation of her name in the records of right Jamabandi on 12/9/2025, and the said application was acknowledged, and the receipt of the said application was acknowledged wide reference number where is that?
My lord, page 29, my lord, NSS 6.
Okay, right. Acknowledgement number, page 29. Dated 12/9/2025. For the notified public service court mutation after deed registration, unquote. Full stop. As the notified public service was to be extended within a stipulated time period, the petitioner kept inquiring into the matter, inquiring with regard to, kept inquiring about the disposal of the application for the notified public service. Full stop. As the stipulated period of 60 days for delivery of the notified public service expired, the petitioner visited the office of the respondent number 3 in order to learn about the outcome of her application. Full stop. As the provisions of the Right to Public Services Act 2012, as amended, has provided a remedy for filing an appeal before the appellate authority for not extending the notified public service within the stipulated period of time. The petitioner preferred an appeal on 23/11/2025 before the respondent number 2, before the first appellate authority, that is the respondent number 2. Full stop. It was thereafter the respondent number, the designated public servant, that is the respondent number 3, had rejected the application of the petitioner, citing reason, quote, NOC not submitted, unquote, there is no NOC from DC office, unquote, on 1/12/2025. Full stop. Pursuant to such rejection of the application by the respondent number 3, the first appellate authority also closed the appeal on 2/12/2025 on the ground that the corresponding application already stood closed. Full stop. As a result of such decisions of the designated public servant and the first appellate authority, the petitioner has been deprived of availing the notified public service mutation after deed registration. Full stop. Para. As the petitioner is aggrieved by the aforesaid decisions of the designated public servant and the first appellate authority, the petitioner can avail the remedy of preferring a second appeal before the Assam State Commission for Right to Public Services, which is the second appellate authority in terms of the provisions of the Assam Right to Public Services Act, 2012 as amended. Full stop. As per Section 8 of the Assam RTPS Act, an applicant aggrieved by any order of the appellate authority can make a second appeal within 60 days from the date of receipt of the order of the appellate authority in the appeal before the commission. Full stop. It has further been provided that a commission may entertain the second appeal after expiry of the said 60 days, but in no case beyond 90 days from the date of receipt of the order of the appellate authority by the applicant. If it is satisfied that the applicant was prevented by sufficient cause from filing the appeal in time. Full stop. The petitioner has, as the petitioner has, sorry. As per subsection 2 of section 8 of the RTPS Act, an appellate authority, before deciding the appeal, is required to give reasonable opportunity of being heard to the appellant, as well as to the designated public servant. Full stop. Mr. Ahmed, the counsel for the petition, has submitted that before deciding the appeal by the first appellate authority did not give any notice to the petitioner to afford any reasonable opportunity of being heard to the applicant. So if it is so, it is required. A reasonable opportunity of being heard is required. Then writ petition is maintainable. We'll set aside this order and to pass a region order by the appellate authority. We are not required to go to the commission. It is there. Nothing has been, they have done it documentally, by documentary thing. CO has submitted a report or he has rejected. So he has rejected. Original authority rejected. He has also rejected.
I will submit your lordship.
Let him.
Online, your lordship, the reasons because of the.
I don't think it is to be read like that. Shall give, after filing of an appeal, a reasonable opportunity of being heard is to be furnished to the appellant. Your exit.
Instructions may be, so lordship will obtain instruction whether the person was being called for hearing or not, your lordship.
There are myriad reasons to set aside this order. I am indicating only one. This is absolutely a non-speaking order. Besides being a non-speaking order.
Instruction.
As per subsection 2 of section 8 of the RTPS Act, the appellate authority may reject the appeal, and in case of rejection of the appeal, the appellate authority shall record the reasons in writing for rejection of the appeal in his order. Full stop. Having regard to the order passed by the appellate authority, first appellate authority, it is seen that the appellate authority had auto-closed the appeal as corresponding application was already closed by the designated public servant. Full stop. Besides being a non-speaking order, no opportunity of hearing has been afforded to the petitioner as the appellant in the appeal. For the aforesaid region, the appellate order cannot stand the scrutiny of law, and the same is liable to be set aside and passed. Accordingly, the appellate order dated 2/12/2025 is set aside and passed. Full stop. As a result, the appeal referred by the petitioner stands restored before the first appellate authority, who shall proceed with the appeal strictly in terms of the provisions of the RTPS Act, more particularly Section 8 thereof, to decide the appeal within the stipulated period of time, within the period of time as provided, as stipulated in the RTPS Act. Post up, it is observed that before deciding the appeal, a reasonable opportunity of being heard is to be afforded to the petitioner as the appellant. There are myriad reasons I tried to save you, but I could not save you.
Alert, in this case, alert, a notice may be issued by the authority.
I said, should I say again?
No,
Reasonable opportunity being heard.
Lordship, the instruction may be kept for.
And I'll keep it for other
Yes,
cases.
yes, sir.
It for you. It all for you. Next.
33.
This submitted an online.
Madam, same thing, Basundhara, 2 or 3. When these cases are ordered to be listed? 18. Mr. Sharma, let it be on 18.
Next
And
Monday, Your Lordship.
Huh?
Lordship has fixed it on next Monday.
Okay.
Item number.
Get the written instruction. I think. Hired Ms. N. Sharma, learned counsel for the petitioner, and Bordoloi, according to list the case on 18. Already ordered, there will be no motion for.
Item 34.
May I please, Your Lordship. On last 25/2/2026, Lordship, Bank Authority was asked to take
Yes.
instruction what they have done after order of SDGM, Lordship.
Formerly siphoned off.
Yes, Lordship.
And M. Chetia. That means, yes, Mr. Hazari.
Lordship, I am APM for respondent number 6. Lordship, we have received an instruction, Lordship.
6.
Who is for the bank?
6, state government is a formal party cyber officer in charge cyber crime, Lordship.
Yes.
Bank authority is the main party who will disperse the money which was put.
Who is Mr. K. Gogoi?
Mr. M. Sharma is there, Lordship. He appeared.
Then in the earlier order, name is wrongly reflected.
His junior appeared, Lordship.
Okay.
And 25/2.
M. Sharma is found to be regularly absent before this court.
But he is
On the
appearing
last
for
two
all the
dates.
banks.
Huh?
He is appearing for almost all the bank authorities, Lordship.
He is found to be regularly absent before this court. Yesterday also, the previous week also.
Mukesh.
What to do? Mukesh Sharma.
I think Mukesh Sharma.
Mukesh Sharma.
Mukesh Sharma, yes. He is appearing for banks, Lordship, generally, I found it. In that case, a date may be fixed, Lordship, let him.
S. Seal.
S.
Yes, what kind of instruction you have? Let us see.
Lordship, the instruction is not sufficient, Lordship.
Not
I think.
sufficient. Tell me, one line. In one line.
He is appearing for cybercrime, Lordship. And the cybercrime is supporting my case. They are pursuing my matter, Lordship. Like it's not.
Although several remainder was sent to the bank authority, but could not find out, Lordship.
And you are operating your bank account where?
Lordship from here, but through bank through online.
1 minute,
Lordship.
madam, 1 minute.
Online mode, Lordship. Lordship, may kindly see order of SDGM page number 16.
What has prompted you to maintain a bank account at Bhagalpur when you are a resident?
Lordship.
When you are a resident of Dispur?
Yes, Lordship. This is regarding
Jamtara?
no,
Huh?
this is regarding investment, Lordship, in stock, and I invest.
No, when you are operating, since when you are operating the account in Bhagalpur?
No, I'm not operating in Bhagalpur. I am operating from Dispur, Lordship. I invested money, Lordship. Page number 16 may kindly be seen, Lordship. Order of SDGM, which is crystal clear that the fraud was happened to me. And cybercrime put on-
Just a minute.
Lordship.
So your bank accounts are at State Bank of India, which branch?
This branch, Lordship. I mean,
Dispur branch.
Dispur.
And HDFC Bank, which branch?
Branch, Lordship. HDFC. I will have to take. From SBI HDFC branch IFSC code I have, Lordship. Account number.
Complainant was defrauded and amount from the government.
After passing of this order, some amounts, Lordship, were disbursed, but some amount were not. That's why I approached this honorable court.
So you were asked to approach the.
Yes, I approached by telephone, Lordship. They were not cooperating. Thereafter, the cybercrime branch also, Lordship, NHN number 19 onwards, they were forwarding mails, reminder to the branches, Lordship. They were not responding. And on last occasion, Mr. Sharma appeared on 25th and said that he will take instruction. What happened after passing of this order, Lordship? Because they were the bank authorities.
Now, who are made parties here?
The banks, Lordship.
Canara Bank.
Yes, Lordship. Canara Bank and yes,
Bank
Canara
of Baroda.
and Bank of Baroda. These two banks are.
And he is counsel for whom?
Both the banks.
S. Seal for the
S.
petitioner.
Lordship.
Yes, Kanongo. Learned counsel for the petitioner and Mr. H.K. Hazarika, learned counsel for the respondent number 6 are present. The learned counsel for the respondent number 1 to 5 bank authorities is found absent today on call, full stop. Though the name of SC Canara Bank and SC Bank of Baroda are reflected in the cross list, the name of quote unquote Mr. Mukesh Sharma be reflected in the respondent side in the cross list. This is the case next week. Give it a date.
22nd May.
Deeply pleased.
Item 35.
Receive our parawise comment, so I may be allowed to extend file affidavit in policy.
Mr. H. Das, learning counsel for the petitioner is present. Mr. H.K. Hazarika, learning junior government advocate, appearing for the rest, all the respondents. Oh. All the respondents?
3 and 4, Lordship.
Okay, 3 and 4. Okay, A. Authorised, standing counsel revenue 1 and 2. Mr. H.K. Hazarika, learning junior government advocate, appearing for the respondent of 3 and 4 has submitted that he has received the parawise comments to file the counter affidavit on behalf of the said respondents and has sought for 2 weeks time to file the counter affidavit. The Procedural raised the case on so and so. For filing of counter affidavit on behalf of the respondent number 3 and 4.
For orders, item 39.
No, lodgeable court's order is there. Okay.
There is no representation on behalf of the petitioner to be on call. Mr. N. Gusami and Uniform Advocate for the respondent number
1, 2.
1 and 2. 1 and 2
Gotcha.
is present. First of peruse the order dated 8/4/2026 of the Lodgima Court. In view of non-representation on behalf of the petitioner to the on call, let the case be listed after 3 weeks on the date to it by the office.
Items 40 and 41.
Service? Service?
Not complete. Wait. 24/2026.
Heard Mr. R.K. Vatra, learned counsel for the petition, and Mr. A. Borua, learned counsel for the respondent number
1A and 1B.
1A and 1A to 1D.
A 1D.
Full stop. Peruse the office notes dated 20/04/2026. Full stop. Which reported that neither ID card nor answer notice has returned till date. Full stop. Please the case on server respond number 2. Otherwise, you will place it before the Lodgima to get it served. Release the case on server 10 days after 10 days. Same in item 41.
There's a little mistake in the office note, my lord. It reflects that it's
As
for
for one.
R1.
For R2.
For R2. We have checked this
Okay,
step.
R2.
No. In item number 40.
Okay. Same order.
Same order for R.
Same order.
Obliged.
For service report in respect of
Respond number 2.
respondent.
Obliged.
Item number 42.
May I please, Your Lordship? Service has been complete as per office note dated 18/3/2026. Your Lordship.
You are serving notice of an MSCT member.
Yes.
Huh?
Yes, Your Lordship.
For what kind of relief? That
Actually-
is a tribunal. Some high court rules. For what purpose you have filed this writ petition?
Since the events of the petitioner is there. Petitioner meet with an accident, therefore he filed an MSCT case for obtain the compensation. That has been disposed of by awarding compensation and amount of 7 lakh something. And out of that, 6 lakh has been fixed for FD, Your Lordship. And in this regard, we have filed a petition for withdraw the amount, premises amount, Your Lordship. That has been rejected. That petition has been rejected.
That is a judicial order.
Yes. We have annexed.
That judicial order cannot be challenged in a writ petition.
We have filed this
A
petition.
judicial order cannot be challenged in a writ petition. 9 judges bench has already held, and this court has already held it. Please go through page 396 and 397 of the Gauhati High Court rules and find out that is an additional reason for dismissal of the writ petition. This is not maintainable.
In this review, we have.
No,
only
we don't allow counsel to commit mistake. knowingly, and this court will not go, that is a subsequent secondary matter. This court will not pass any order against its own order. I have already held.
Lordship.
Any writ petition against any judicial order is not maintainable. But this is not my view. This is a view of 3 judges bench, 9 judges bench, 7 judges bench of the Supreme Court. Go through it. Norris Miraj, 9 judges bench. It would be a case of at best 227. Heard Mr. S.I. Akal, learned counsel for the petitioner, Mr. Yes, Mr. Sharma.
Lordship, in
What is your, you have been,
they have filed a petition under Article 227, Lordship.
Ah.
26. And we have not received any instruction from the registry also, Lordship. This is not the petition
is
under
it a
227.
227?
Lordship. Yes,
Ah,
Lordship.
227, then this should be registered as CRP. It is to be registered as a CRP. Why 226? WBC, what is that case? Supreme Court. That all 227 case is to be registered as CRPs. Move orders. Okay, the service is complete. When Mr. Das will be available?
Lordship, Lordship, after 2 weeks, Lordship.
Not
No, Lordship,
what?
because Lordship, we have not
What
received any
matter?
instruction, Lordship.
What is required? It is to be converted into a CRP.
Lordship, then next week, Lordship.
Release the case on Friday.
Lordship.
Tell Mr. Das to come.
Lordship, deeply Lordship.
This is to be converted into CRP. They have filed in under 227. Registry has committed a mistake. It is to be converted into CRP. Thereafter, it has to be proceeded with. It is maintainable. Mr. Akon, you have filed it 227.
Yes, sir.
Correctly.
Applies.
Bit 3.
Iman?
May I please, Your Lordship? Lordship, I have received a copy of affidavit in opposition, Lordship. Just today, Lordship, from my clerk, Lordship.
Issue notice.
Well, the order allays is the direction of the Honorable Court not to interfere with their
You have appeared for?
Respondent number 1.
Who are 2 and 3?
2 is the executive engineer of Hailakandi Water Resource, and the 3 is the circle officer Hailakandi.
Okay, they are not served. Okay. Now you have received the affidavit. Yes.
So, some time is required, Lordship, to further action, Lordship, from my petitioner's part, Lordship.
And this contempt case is for what?
Well,
Lordship, for violation of the order, Lordship, of Lordship, status order, Lordship.
Direction kindly come to my Lordship, page number 13. Page 12 and 13. 12 last sentence, my Lord.
12.
Given the facts and circumstances in which the IA has been preferred, the respondents are directed not to interfere with the position of the petitioner on the land covered by the periodic patta number so and so, without the leave of the Honorable Court. These are the lands which is under position of the petitioner. There is a construction of dike, my lord. Construction of dike.
Road come dike.
Road come dike.
Dike.
Okay. In our affidavit, in fact, the DC has we have stated, kindly, Lordship may kindly take up our affidavit at page 29. In fact, the contractor who was engaged there, this is a
page. Tell me the annexer.
Page 29. Page 29. It's a
29.
part. It's a part of para 4 of our affidavit. I'm just indicating what has happened, Malon. In fact, there is some on the part of the contractor, a tree he has done some work mistakenly. I'm just reading, Malon. The deponent by letter dated 23/3/2026 informed the Executive Engineer Water Resources Department Hailakandi that by an application dated 11/3/2026, Sahabuddin Borboya and Farooq Ahmad Loskar, he is the petitioner, had informed that despite the direction of the Honorable Court, the concerned contractor has continued with the construction work on their Patta land. It is informed that the matter has been viewed seriously and accordingly the deponent has directed the Executive Engineer, Water Resources Department, Hailakandi, to inquire into the matter and to issue a show cause notice to the contractor and to take necessary legal action against him as per norms. The deponent also directed the Executive Engineer, Water Resources Division to ensure that no work should be carried out in the land of the petitioner till the final judgment of the Honorable Court and to submit an action taken report immediately. Thereafter, the Executive Engineer, Water Resources Department, Hailakandi, by letter dated 24/4/2026, informed the deponent that certain unauthorized restoration activities, including cutting of trees and dumping of art, was carried on within the petitioner's land in violation of the Honorable Court order. In view of the aforesaid violation, a show cause notice was issued to the contractor and action has been initiated as per rules. In response to the same, the contractor has submitted a reply to the show cause along with an affidavit attributing the incident that there was a small tree which was tilted over the dike by the recent storm, which obstructed plying of dumper of the tipper up to the place of work and in presence of
Let them respond then.
Lordship.
They have to respond to this statement.
In fact, the reply says that the petitioner was also present.
No, yes, but we have seen that your deponent says on 23/3/2026, Executive Engineer responded after 1 month. Let him reply. Let him reply. Heard, Mr.
Now, that has been taken care of and the specific instruction has been given by DC and they have also.
Actually, not like that, Lordship. I will respond, Lordship.
B.U. Loskar for the petitioner and Mr. D. Nath, learned counsel for the respondent number 1. So the respondent number 1 has already filed an affidavit in opposition. First up, Mr. Loskar has sought for and is granted how much time you need?
2 weeks, Lordship.
2 weeks time to file an affidavit in reply to the said affidavit in opposition. So peruse the office note dated 7/5/2026, which has reported that neither ID card nor answer notice has returned back after service from the respondent number 2 and 3. Await for the service reports in respect of respondent number 2 and the respondent number 3. Is the case on? Did you?
3rd June. Possibly he is appearing for some.
Please come this side. You have entered appearance for whom?
RM Das, madam. Respondent number?
For respondent number 2.
2. Mr.
V. Keso.
P. Keso, learned counsel. On behalf of Mr. R.M. Das, learned counsel has submitted that he has instruction to appear on behalf of the respondent number 2 and the necessary Ukala number will be filed recently. He has further sought for and is granted 2 weeks time to file the affidavit in opposition of the respondent number 2 on behalf of the respondent number 2. Itu khali ঠিকানা রাখি দিব বাকি পার্ট
Lord. 3rd June.
Item 44.
Here, Lordship, I pray for some time, Lordship. My affidavit has gone for vetting, Lordship.
Okay, Mr.
MN Konya.
MN?
Yep, on behalf of G. Chaudhary.
Learned counsel appearing for the petition of Mr. S.S. Roy, Learned Junior Government Advocate. Appearing for the respondent number?
Respondent number 4.
Deputy Commissioner?
Lordship.
Respondent number 3 has sought for and is granted 2 weeks time to file counter affidavit. The earlier order of status quo, passed on 30/3/2026, shall continue till the next date of listing. List the case on so and so.
5/6.
Obliged.
Item 45.
May I please, my lord? My lord, today I'm preparing for allow me to withdraw this application, Lordship.
This IA.
Yes, Lord.
Mr. Sharma.
MM
Jaman.
Yes, Lord.
MM Jaman, learned counsel for the applicant. has submitted that the applicant does not want to raise this application. Mr. S. Bora, Learned Standing Counsel.
GMC for respondent.
GMC. For the respondent number 5 is present. In view of the above submission made by Mr. Jaman, the instant interlocutory application is dismissed on withdrawal.
Withdrawal, one pair, Lordship. Lordship, I may be allowed to collect the new address of respondent number 6. For that 2 weeks time.
In the main repetition, heard Mr. M.M. Jaman, Learned Counsel for the petitioner. J. Hendrik, Learned Junior Government Advocate for the respondent number 1, 2, and 5, and Mr. S. Bora, Learned Standing Counsel GMC for the respondent number 3 and 4. Mr. Jaman has sought for 2 weeks time to has sought listing of the case after 2 weeks in order to collect the correct address of the respondent number
6, Lord.
6 in the meantime. The praise allowed. List the case after 2 weeks.
Petition number 5520, Lord Citizen. It's a dispose of
No, I don't know.
792. 792.
Highly obliged, Lordship.
The earlier order, interim order, the interim order passed earlier shall continue till the next.
Item 46.
May I please your lordship? As
Well,
per
service-
dated 22/4/26, service has been completed upon respondent number 8
Heard Miss
and Sodhuri.
Ann Chaudhary, petitioner.
My lord, I am appearing on behalf of person number 8, my lord.
8.
Yes.
As Dr. Standing Counsel. Concerned in Rural Development Department for the respondent number 1, 3,
1, 5,
5,
1, 5,
5,
6, and 7.
6, and 7. And Mr.
A. Hussain, my lord.
A. Ismail.
A. Hussain.
Oh, A. Hussain, Learned Counsel for the respondent number
8.
8. J. Hendrik, Bazoliki, Junior Government for the respondent number 2 and 3. And Miss Okay. Learned Counsel on behalf of Ms. S. Kotogi, Learned Standing Counsel, Election Commission of India for the respondent number 4. Poster. As all the respondents are represented, release the case. Also, and so in the admission column.
After 4 weeks, my lord. In the meantime, I will, my lord.
Okay.
Well, Lordship, it's filed already, my lord.
Huh?
Not maintainable, my lord.
Which one?
This
Okay.
case, my lord. Remain repetition.
Okay, then let us.
Law point of view.
Please on a shorter date.
Yes. Because
As Mr. Dotto has raised the question of maintainability of the repetition.
25th May.
Well, highly obliged.
Item 47.
Yes, Mr. Zaman, why it has come?
We have taken the step, Lordship, but service report is awaited, Lordship. Upon respondent number 3 to 5, Lordship.
Okay.
My lord, I am
Zaman.
my lord, I am appearing for respondent number 3, 4, and 5.
Here he comes.
I have filed Ukalat number 2 date itself.
Lordship.
Then how much time you need?
3 weeks time.
3 weeks time. And state, SK Hazarika.
Not so.
Heard Mr. M.M. Jaman, Learned Counsel for the petitioner. And Mr. HK, Mr. Bhattacharya is there. A. Bhattacharya is Standing Counsel Revenue Department for the respondent number 1, Mr. H.K. Hazarika, Learned Counsel, Junior Government Advocate for the respondent number 2. Mr.
A.K. Azad.
A.K. Azad, Learned Counsel has submitted that he has entered, he has instruction to appear on behalf of the respondent number 3, 4, and 5. You have filed Ukalatnama.
My lord, 2 date.
And he has already filed a Ukalatnama to that effect. Mr. Jaman, both Mr. Hazarika and Mr. Jaman have prayed for and are granted to obtain necessary instruction and to file their respective counter affidavit. Release the case on sales in the admission column.
Admission column. Highly obliged.
Item 48.
There is no representation on behalf of the petition to and call. Mr. H.K. Hazarika, Learned Junior Government Advocate for the respondent number 1, 3, and 4 is present. Mr. Dotto has gone. Panchayat. ICDS is okay. New. Peruse the office notes. Dated 21/4/2026. Full stop. Await for the service reports in respect of respond number 2 and 5. Hazarika is you are for 1, 3 and 4. Okay. Yes, morning is a Khandeli or some. Yes, yes.
49.
Sorry, I thought that it would be over, but what is the issue about?
My lord, this is an application for winding up of the petition.
We'll not hear, we'll just initiate. We'll only initiate, just sum and substance, summary. Yes, what is the case about? One IA is there, one company petition is there, another IA is there.
2 IA is there.
2 IA is for what purposes?
1 IA filed by the respondent number 1, 2, and 3 that this petition is not made. Another IA is filed by me, my lord, that this matter is required to be transferred to the NCLT in view of insertion of fifth proviso under the Companies Act section 273. So the entire matter is required to be transferred to the NCLT by way of amendment in the Companies Act. These are the 2 IAs.
Okay. And Mr. Khandelia has filed the IA regarding non-maintainability.
Lordship.
On what ground? Otherwise,
Basically,
I'll not look into the paper.
No,
You just say orally.
on the ground of Companies Act 293, we said that there was no resolution to grant loan. Number 2, that the claim loan was granted in the year 2001, company petition filed in 2015. We said that this is barred by limitations. Number 3, there are difference from their own pleading and the document available on record. There are disputed matters of fact. We have prayed that some document has been forged. So and then they are not registered under the Money Laundering Act. So all this, taking all this issue into consideration, we filed the maintainability.
And who has filed the other IA?
They have filed.
Okay, the company petitioner.
Yes.
Okay, that is IA 2575.
My IA is 257.
And Khandelia's IA is
2276.
So which is to be taken up first?
My lord,
Lordship, there are orders.
Which one?
Lordship, in the
egg or the hen?
Lordship, otherwise our
Which one is the egg? Which one is the hen?
Lordship, there are order 2,
If
3
your petition is allowed, it is dismissed.
It is dismissed.
If his petition is allowed, then
We have
it
to
will be
argue
transferred.
there.
Now, which one is to be?
Lordship, there are orders passed by this honorable court stating that both IAs has to be heard simultaneously.
Okay.
There are orders on record.
Okay.
and in their IA, my lord, we have filed the reply that since the matter is for transfer, so their matter may be taken care by the NCLT. That is our plan.
Okay. 28 ত কিবা আছে?
We have taken few points that why this matter cannot be transferred. We'll argue on that also. Lordship.
28.5.
Lordship, can it be on second? I am led by K.N. Chaudhary, senior advocate.
We'll start
if possible.
28.5.
28.5. Much obliged.
Because I'm not very abreast with all these provisions, I have to read also.
Lordship.
Mr.
V.K. Chopra.
V.K. Chopra, learned counsel for the petition, and Mr. G. Khandelia, learned counsel for the respond number 1 to 3. And Miss N. Rahman, learned counsel for the respond number 4 are present. Full stop as sought for and agreed to by the learned counsel for the parties, leads the case on 28/5/2000. On a hearing day,
Yes.
we'll try.
28/5/2026.
Much more.